Ladies and gentlemen, I, Shobit Mohan, Assistant Professor at Faculty of Law, Manavrachna University, welcome you all to the second installment in the Construction Law series, a masterclass on effective management of complex construction arbitrations, organized under the aegis of Center of Excellence in Alternative Dispute Resolution and jointly hosted by Young Leaders Group, SCLYLG, Link Legal, Suveeksha, with our knowledge partner, Pinsett Masons M. Pillai, supported by Singapore International Arbitration Center, with media partner Bar and Bench. We are a very young law school located in the Aravali Hills in Surajpur, right on the Delhi-Faridabad border. We offer a 5-year undergraduate program in LLB and also postgraduate program, including an LLM in commercial arbitration, which is perhaps the only one of its kind in India. Ladies and gentlemen, today we are indeed privileged to have with us a very illustrious and diverse cast of speakers. And before I hand over the session to our moderators, let me briefly introduce. Ms. Padmaja Kaul is currently a partner at Indus Law. Her areas of specialization include, but not limited to, commercial disputes, arbitration, and insolvency. In her previous stint, she was a counsel at Trilegal for 7 years, completed her master's in law from University College London. In addition, we have with us Mr. Shashank Garg, who is a seasoned dispute resolution practitioner skilled in international commercial arbitration, sports arbitration, construction law arbitration, civil and commercial mitigation and mediation and litigation, with over 12 years of experience. Currently, he's a partner at Advani & Co, and he's in charge of the Delhi office where he handles commercial litigation arbitration verticals. He's also the panel counsel for GAIL India Limited, special counsel for Hindustan Copper Limited and Delhi Development Authority, and an advisor to Faculty of Law, Manavrachna University. He has edited the book Alternative Dispute Resolution, The Indian Perspective, published by OUP, and also authored a book titled Tourism Law in India, published by Universal Law Publishing. So without further ado, I request Ms. Padmaja Kaul to take over the session. Over to you, ma'am.
Thank you very much, Shobit. Good morning, everyone. I would like to express my gratitude to everyone here who has joined us today. I know that I speak for everyone here when I say that we're absolutely thrilled to have such distinguished speakers amongst us. So without much further ado, allow me to set out the context for today's masterclass: effective management of complex construction arbitrations. I'll give the organizers credit for having taken the liberty to include the word complex in the topic itself. In my experience is probably the most apt description for construction arbitrations. And our distinguished speakers here today will probably help us unravel some of these complexities. Construction disputes usually include thorny and technical questions such as delay, risk purchase, cost overrun, defects, etc., all of which require interpretation of the contract, review of voluminous documents, extensive evidence to be led by fact as well as expert witnesses, and the list goes on. This not only entails a legal challenge, but also becomes an administrative and management nightmare for most. Having said so, I must note that our legislature and judiciary have not been silent spectators, be it the amendments to our domestic legislation to make arbitration time-bound and efficient, or the precedents declaring our legal system to be pro-enforcement. We have truly advanced the Indian jurisprudence in this regard. Our core legal regime appears to be moving in the right direction. However, I think we still need to be more robust in incorporating international best practices in our domestic sphere. We will also today be touching upon some of the international best practices and procedures for strategically and efficiently managing a construction arbitration. These include concepts such as bifurcation of issues, deciding them by a partial award, use of the Scott schedule, adoption of the chess clock procedure during hearings, leading evidence through witness conferencing, among others. In fact, arbitral institutions such as SIAC have been flag bearers when it comes to bringing in such techniques to the international arbitration community. Today's masterclass would also be left incomplete without touching upon how technology has come to our rescue in the midst of the current pandemic, with virtual hearing being the new norm for not just the management conferences, but even for recording evidence. We are currently, certainly witnessing, the advent of something we may call, in the truest form, online dispute resolution. These are just a few of the topics our distinguished speakers will be delving into today. With these words, I am pleased to state that we have an enviable batting lineup for today. Our first set of speakers are Mr. Nusrat Hassan and Mr. Anand Srivastav. Mr. Hassan, who is the co-managing partner of Link Legal, has more than 2 decades of experience in domestic as well as international commercial arbitrations. Mr. Hassan is also a qualified solicitor in the UK and is a fellow of the Chartered Institute of Arbitrators London and secretary of the Chartered Institute of Arbitrators India branch. Along with him, we also have his colleague, Mr. Srivastav, who is also a partner at Link Legal and brings with him the expertise of also being a qualified New York practitioner. Over the years, Mr. Srivastav has developed a niche in handling complex construction disputes in India and internationally. Before we engross ourselves into this masterclass, a few housekeeping rules request all participants to keep their videos off, mics on mute, and in case of any questions, to put them in the chat box. We will definitely collate them and bombard our speakers later in the day with those. So without much further ado, I would now invite the opening pair, Mr. Hassan and Mr. Srivastav, to take the crease and educate us on today's topic from an Indian perspective. Gentlemen, I hand over the floor, rather the control of the mouse to your adept hands.
Thank you, Padmaja.
Thank you.
I'll just put up the slides. Great. So I think as Padmaja pointed out, construction arbitrations and construction contracts and disputes arising out of construction contracts are clearly a distinct body of disputes from other parts of disputes. They are highly technical and complex in nature and almost always call for urgent attention and involve, in many cases, multiple parties. Issues of joinder and consolidation gain prominence to these disputes like no other dispute forms. Construction contracts involve several risks and resultantly witness a greater need for effective allocation of risk amongst various parties. And therefore, it is very important that, the effective management of complex construction arbitrations is considered as a matter of great, importance. Ascertaining the liability of a party, for example, in a string of parties requires careful study of responsibilities and obligations of each party, the nature of commission or omission resulting in breach of obligations, and calculating the quantum of damages. Considering the fact-sensitive nature of disputes and the need for quick resolution, it is quintessential that we deploy effective case management techniques in construction dispute resolution. We will be broadly covering in 5 sections the principles of effective management. Firstly, we will of course look at the effect of the recent amendments. We will look at a few pre-arbitration strategies in domestic arbitrations. We will then move to strategies during the arbitration process. We will also discuss the present status of virtual proceedings in India and how the courts have kind of adapted to the whole virtual proceedings scenario. And lastly, we will touch upon briefly the very big topic of enforcement of awards and the entire hands-off approach that the Indian courts have adopted. For section 1, I think I'll hand over to Nusrat.
Thank you, Anand. Thank you, Padmaja, for the introduction. Good afternoon, ladies and gentlemen. Anand has already set out the plan for our next 1 hour odd session and how we are going to take this forward. I think on our first subject matter, which we are going to discuss, is the recent amendments. I think before I speak of the amendments, I think it is important for us to understand the historical evolution of how arbitration has evolved in India. Once you understand, or once you have experienced and understood that, you understand why these amendments have come about and what is the effect that it has had on the overall landscape of the arbitration in India. I think it has had a tremendous effect on how arbitration is done today versus 10 years ago. I recall, I think this is an experience which everybody would have faced one way or the other. Why you started an arbitration, but you never knew when it was going to end. In fact, I remember trying to instruct senior counsels in the matter was another challenge. They used to say, "No, sir, don't get us involved in arbitration. We just cannot find, we cannot time ourselves. We don't know when it's going to end, and it's definitely not satisfying as a profession." I think there was a whole set of problems that had been created. But just to start, how it's evolved right from 1940, when we adopted really the modern arbitration law right way back in 1940. And in fact, in 1980s, we had a judgment, forward-looking judgment in Renu Sagar, which was very progressive, and in fact defined to a large extent what public policy could mean. And we all know public policy is an unruly horse. And then in 96, we adopted a very modern law, which was in line with the UNCITRAL model law. And we had a new Arbitration Act in Arbitration and Conciliation 1996 Act. All well, not too bad. Then in the 2000, from there on started trouble. There were judicial decisions which resulted in excessive judicial intervention. Now that created a huge problem. Almost, if I may be bold enough to say, that it almost made arbitration ineffective. Arbitration ran for years. Then after that, the challenge of award would run into several years. So you could find arbitrations, at least the large ones, go by the time you landed up in Supreme Court, you would end up in 8 years, 9 years. So it just, the whole effectiveness of arbitration was lost. You're reminded of a statement by Gary Bond, in fact, way back in NTPC judgment, where he said that this is one judgment where I find that this judgment is aggressively nationalistic. So we had these problems in enforcing these foreign awards. Anand, can you take it to the first slide, please? Yeah, thank you. So there were many. The amendments that started from 2015 till date, I think we're going to quickly run through that. I'm aware there is a paucity of time and we have a lot of topics to cover. But I think I haven't gone by any seriatim or any order specifically, because I thought we could discuss on the basis of what we think have been pretty large issues which have been amended over a period of in the last 5.5 years. The first one, of course, which changed the landscape, which also was a matter of great discussion, was with reference to 29A, which basically said arbitrations have to be time bound. Now, this really comes, we have to understand that the 2015 amendments primarily came for two reasons. Or let's say the amendments overall, 15 and the 19 amendments are primarily for two reasons. As I mentioned, from 2000 onwards, we had these judicial decisions which had completely made the arbitration ineffective. So the 2015 amendment was primarily to overcome these adverse judicial decisions. So this was really the primary reason why the 2015 amendment came. The 19 amendment was primarily to make India as a hub for international arbitration. So here are two specific reasons or objects which the legislature had right at the early stage and which really understood why these, the reason why these amendments need to happen and why it has taken place. I think it's important. So this is from these facts. So first major change was the time-bound arbitration. Of course, in 2019, basically the arbitration needed the award had to be given by the arbitrators within 12 months. With another extension, extension could be given for another 6 months between by consent of both the parties, and thereafter they needed to approach the court. Now, approaching the court, which in our experience, we did that a few times, and the extensions that were given were normally for a very short time, and the courts were exercised this discretion not so easily. I mean, the court used to inquire why they needed. You had to give reasons, etc. And the legislation provided, the amendment provided for the court to be able to reduce fees and even replace arbitrators in certain cases. In the 2019 amendment, primarily 6 months further was added. So now you have 6 months for pleadings in which you need to finish, and thereafter within 12 months after the completion of pleadings, you need to pass an award. And again, you have the 6 months extension with the consent of both parties, and thereafter you need to approach the court. Suddenly we have a timeline, and this is unique to our country, to India. But this was, in my humble opinion, much required, because I think most of the practitioners would agree has completely changed what arbitrations looks like in India now. Thereafter, I think what also finds a substantial mention in our presentation here is the amendment which happened with reference to Section 11. Now, basically, the amendment to Section 11, the Section 11 in this section, the court, the amendment clarified that the power under Section 11 would be exercised by only judges of the Supreme Court and the High Court. Then it added a language. It restricted the scope of examination by the court only to the existence of the arbitration agreement. It further clarified that the delegation by the Supreme Court or High Court to any person or institution would not be a delegation of judicial power. So it was not a delegation of judicial power, but it was more administrative in nature. Stated that 11 would not be subject to an appeal, obligated the court to try and expeditiously dispose of an application under 11 within 60 days. So these were some of the changes that were made. This was the amendment which really came in 2015. But then we had a lot of discussions, that we had some judicial, we had certain judgments from the courts, and the court started dwelling on what does existence mean, existence of a valid agreement, right? In 2017, in fact, in the judgment of Duro Filgoro, where it was clarified that existence of an arbitration agreement only requires the relevant court to see whether the arbitration contains a clause which provides for arbitration pertaining to the dispute and has arisen between the parties to the agreement. So that's the only test they needed to do. But however, there were many judgments which were to the contrary, and it started creating a lot more confusion and delaying right at the stage of appointment of an arbitrator. By 2019 amendment, 11(6)(a) was deleted, which was basically where under that provision, and in 2015, the legislator had brought in the existence of arbitration agreement. Now, by the deletion of 11(6)(a), which now means that Supreme Court and High Court no longer require to determine the existence of arbitration agreement under Section 11. So all along, the idea is to be able to provide, to be able to I think 11 with reference to appointment of arbitrator was largely, as always should be, an administrative function, and for some reason or the other it has led to it has led to judicial function and has led to many confusions. So 1168 2019 stands deleted. Then, once notified arbitral institution designated by Supreme Court. So this is another thing which we have been influenced by the Singapore and the High Court, where the Supreme Court and High Court now can designate arbitral institution for the purpose of appointing arbitrators. This still needs to be notified. And also by doing this, they have also simultaneously promoted institutional arbitration. Once this is notified, arbitral institution designated by Supreme and High Court will require to dispose of the appointment within 30 days from the date of service of notice on the opposite party. Next page, Anand. In 2015, another amendment, which was, I think, rather critical and important, was introduced the concept of independence and impartiality for the first time while considering the appointment of an arbitrator. This is the first time a legislative color was given. The fifth schedule serves as a guide. So there's a schedule which has been provided as a guide to determine whether circumstances exist that give rise to doubts with respect to independence and impartiality of an arbitrator. The fifth and seventh schedule, in fact, overlap with each other. And as the facts constituting disqualification of the seventh schedule are in the personal knowledge of the arbitrator. 2019 amendment had made it mandatory before appointing an arbitrator to seek a disclosure from the prospective arbiter with respect to the qualification and other consideration as per the form prescribed in the sixth schedule. So as you see, that between the fifth, sixth, and seventh schedule, the legislature has brought the whole concept of a test by which the arbitrator's independence and impartiality can be tested. I think it's an important amendment that has been brought in, because this provides, this allows a party to reduce the challenge in a 34, because due to raising of issues of impartiality or the independence of an arbitrator. So this is in line with something which an institution does, but this is now by bringing in this amendment, this has certainly assisted in ensuring a much more efficient arbitration process. Can we go to the next slide, Anna? I think one of the note in the earlier of this, which I think I should point out, the fifth schedule is drawn from the red and orange list of the IBA guidelines on conflict of interest in international arbitration. And in fact, the seventh schedule is drawn from the red list of the IBA guidelines. So that is from where these schedules have been prepared. So they are quite robust in that sense. Next is the next amendment was with reference to Section 8, where the courts can refer the parties to arbitration where there is an arbitration agreement. For domestic arbitration under Section 8, the test is that the courts have to refer the parties to arbitration unless it finds that prima facie no valid arbitration exists. By introducing in Section 8 the words any person claimed through or under him, this was brought in the scope and doctrines on the basis of which non-signatories could be bound to arbitration, thus bringing in consonance with the position of other jurisdiction. So this was primarily because of the reason that we had a judgment in chloro controls, which was in the context of Section 45. Now, Section 45 already recognizes the right of a person claiming through or under such party. So this amendment was introduced to just bring it in line with what was already existing in section 45 with reference to international arbitration. So they brought in this amendment by which under section 8. So now it basically allowed a non-signatory under certain contexts, a non-signatory could be made party to an arbitration. So this is very much in as per the international jurisprudence. I think it's been a good amendment, and again it has provided a robust process and also a clear thinking process for the arbitrators when they need to deal with this particular issue, which is quite common. In 2019 amendment, section 45 amended to clarify the judicial authority refer to arbitration unless it prima facie finds that the agreement is null, void, inoperative, and capable of being performed. Can we go to the next slide, Anna? So this, I think if you can just, I'll just end with my previous slide. If you can go back, just needed to add one thing. In the amendment which was finally brought in section 45 was slightly different from what the Law Commission had recommended. Law Commission had recommended basically saying that if a judicial authority is of the opinion that prima facie the arbitration exists, then it will refer the dispute to arbitration and leave the existence of agreement to be finally determined by the tribunal. If the judicial authority concludes that the agreement does not exist or null and void, then the conclusion shall be final and not prima facie. But however, the words which were used were not in line with what the Law Commission, what the Law Commission had recommended. Can we go to the next slide? I think one of the other amendments which finds a specific mention is the reduced court's intervention once the arbitral tribunal is constituted. Now, one of the main reasons for bringing in the 2015 amendment was to ensure that the judicial intervention is reduced. Now, with what the legislature has done, and I think they have been in the right direction. What they have done is provided the tribunal empowered the tribunal under section 17 and reduce the intervention when a party can approach under section 9. So there are only certain now under much less ground that you can approach section 9. Under section 9, the courts instead what the legislature intends that for any interim relief you should approach the tribunal rather than the court. Now, in fact, and of course, at the same time, to ensure that the arbitral tribunal have been provided the same powers that a court has under section 9, including appointment of court receiver. Now, in Alka Chandevar, the Supreme Court observed with the addition of the subsection 2 of section 17, such orders would be deemed to be orders of the court and for all purposes would be enforced under the CPC in the same manner as if they were orders of the court. Section 9 allows a party, you are permitted to approach the court, of course, during and commencement of the arbitration, subject to the below amendment. Under what instance can you approach the court? Section 9 now allows a party to approach the court only under circumstances where the remedy rendered under section 17 of the Arbitration Act is not efficacious. In a judgment, what is not efficacious? It has been held, the court held not efficacious and allowed the party to approach under section 9 when the tribunal had recused itself. So that was considered as when under 17 you could not get efficacious remedy. Therefore, you could approach section 9. So in fact, so that's so it's a very under very rare circumstances now that you would need to show why you are approaching under Section 9, because now under 17 the tribunal has been empowered. Again, this is allowed arbitration to be run as per the international jurisprudence. Tribunal has now empowered to enforce its orders. It's been given teeth. So I think that's it's an excellent development which has insofar as arbitration is concerned in India. To ensure timely initiation of arbitration by a party that is granted relief by the court under Section 9, the amendment expressly provides that the party is required to commence the arbitration within 90 days from the date of the order of such further time directed by the court. The reason primarily being this amendment is that it was very common that parties would go to the court, obtain an order under Section 9, and thereafter sit with it for months, sometimes years. And now with this particular amendment, that you need to commence the arbitration, invoke the clause, commence the arbitration within 90 days. In fact, in patent construction, failure would automatically vacate the order as held by the Karnataka High Court in patent constructions. I think there's another slide. Yeah. I think with that, I will hand over the baton to Anand for the next set of slides. Thank you. Anand, over to you.
Thank you, Nusrat. So I think, thank you, Nusrat. Can you hear me?
Yes, loud and clear.
Okay, great. So I think the second leg of our discussion today on the effective management of complex construction arbitrations deals with what needs to be done before the commencement of arbitration itself. And I think one of the most important aspects there, given that Nusrat just explained chloro controls, is the role of the arbitration agreement and what it provides. Clearly, of course, most of us understand what the arbitration agreement is about, but just a few do's and don'ts. The arbitration agreement should be clear and unequivocal in its intention of the parties to have the disputes settled through arbitration. The disputes capable of reference, the scope should be clearly stated. If there is a multi-tier dispute resolution process, then the arbitration agreement should be clear in the pre-arbitration contractual steps that need to be taken. The appeal process could be written in the arbitration agreement. We have recently seen a Supreme Court decision where the Supreme Court upheld that the review from an award could go to another tribunal, and then that tribunal then passes another decision, and then that decision is subject to appeal, and that was upheld in the interest of party autonomy. So clearly, the arbitration agreement could prescribe for the appeal process also, which is again very, very, very new. The arbitral tribunal, its constitution, what is the criteria of the arbitral tribunal? Do they need to have any qualifications, etc.? Institutional or ad hoc? India today offers, of course, a lot of institutions, DIAC, CADR, it should identify the seat and venue distinctly, although this issue is fairly resolved now. Specify the governing law and specify the law language of arbitration also. A lot of arbitration agreements provide for the word may, and that should be avoided because it should not be a mere possibility or contemplation of reference to arbitration. It should be a binding, commitment to refer the, as I said, clear and unequivocal intention. It should have a specific description of the scope of disputes and what is covered or accepted as disputes capable of reference. And right to arbitrate should be available to all. It should not be that only one party has has the right to refer to arbitration, and it should not be oral. An arbitration agreement by our Arbitration Act requires that it be a written contract, and it should not be inconsistent with the procedure prescribed under Indian law, such as violative of the principles of natural justice, etc. So we straight away deep dive into one of the case studies that we have. So over here, what had happened was that the contract arrangement was as follows on the right side. Here, there was a concession granted to the concessionaire to construct a road project, and we had the regular NHAI concession agreement. The concession agreement also had two state support agreements, which was one was with the government of Punjab and one was with the government of Haryana. And so over here, what happened was that, of course, if I can, ask you to imagine, just there was where the toll was there, where the passing vehicles have to give the tariff or get the slip and all. Just before that, the governments had service roads built, and the service roads kind of gave an escape path to the traffic, the heavy traffic where the toll is like collected to the toll gate. And so there was a lot of traffic leakage because of non-compliance under the respective state support agreements. Both the state governments, after the grant of the concession agreement, kind of breached the concession agreement and strengthened the service roads to so the people used to drive on the highway and then just before the toll go off and then rejoin the highway once the toll is crossed. So the process that was prescribed, and all the three contracts were inconsistent in their arbitration clauses. So the process that actually transpired when all the three contracts were read together was as follows. The process recorded the concessionaire to first raise a claim with NHAI for the determination of a loss. After the determination of the loss, the contract required, if it was a breach of the state governments, then it required the concessionaire to go under the state support agreement, saying that now between so far as between NHI and me, we have decided that the dispute is now done. The This is the quantum of liability, and it falls between the two of you. The governments could then respectively accept or not accept the decision of NHI, and possibly potentially the concessionaire would have had to fight first NHI and then the two governments. And in case of non-payment by the state government, ultimately, if you win from the state government, the claim was maintainable against NHI for the final payment. So it was like, the NHI concession prescribed that first you win against NHI, then you go to the state governments to see if the state governments pay you. If the state governments don't pay you, then you come back to me and take the money. So over here, what was done was a petition was filed before the High Court of Delhi. Of course, this was because it was against the government, it was a writ petition. And the contention taken by the concessionaire, this was of course done by our firm only, but the contention taken by the concessionaire before the Delhi High Court was that there would be a possibility of conflicting awards in all the three arbitrations. It was a common question of law with common facts and issues, and therefore under the concept of related disputes as it was then under international law, we asked for a prayer of aggregation of the claims. Now, during the course of arguments, two things transpired. Firstly, the state of Punjab and state of Haryana agreed to give up the plea that the dispute should be first adjudicated by NHI. So the staggered process under the concession agreement was agreed to be amended. And secondly, NHI, state of government and state of Haryana were directed by the court under their respective arbitration agreements to refer it to constitute, to the same nominee arbitrator. So the same nominee arbitrators were appointed under the respective three agreements so as to constitute a common tribunal. And the court held this again only because of the common questions of law. The court in its direction said that it was a common question of law. And of course, the court held that it was in the interest of all concerned and in the interest of speedy resolution. This order was, of course, upheld by the division bench later on. So this was a very, I think, if I may say, a common example that is seen, especially in the construction road industry, where we have state government concessions regularly. The next case is the Amit Al Shah case. This case is subsequent to the chloro controls case that Nusrat was talking about. In the chloro control case, of course, there was a group entity concept, so it was easier to aggregate the arbitration agreements under one party. Over here, what had happened was, it's a very interesting case of a solar power project. Here, what had happened was there were agreements with Juvi and Rishabh Enterprises for purchase of PV cells, and one contract was for equipment and material supply, and the other was for installation and commissioning of a solar power project. And these two contracts had an arbitration agreement. The second contract was with Aston Field, where Rishabh Enterprises again agreed with Aston Field for sale and purchase of PV cells. But interestingly, this contract did not have an arbitration agreement. And then there was a third contract, which was the ultimate contract, which was with Dante Energy, where Rishabh agreed that the source of material and the installation commissioning would be done, and the installed solar plant would be delivered to Dante, and then Dante will give lease rental to Rishabh Enterprises. And of course, Dante had the overall concession from the UP state government to produce energy and transmit it to the common grid. So if we see, simply put, this is the grid that emerges. Although of course the facts were a little bit more complex, but we tried to simplify it in the context of what we are trying to discuss over here. So in the first agreement on 1st February 2012, which was between Rishabh and Juvi, the arbitration agreement was provided for Bombay. The second agreement on 5th March, which was between Rishabh and Aston Field, which was again for purchase of equipment, there was no arbitration agreement. And third agreement, which was between Rishabh and Dante, which was for lease of the completed plant, there was arbitration at Bombay. Now, what happened thereafter was that Dante defaulted in lease rental payments, and Rishabh filed an FIR against Aston Field and Amit Shah, primarily arguing that Aston Field and Rishabh and Dante Energy were owned by the same person called Amit L. Shah. Dante, in the meanwhile, invoked the arbitration agreement under the equipment lease agreement. And Justice Sujata Manohar was appointed, an arbitrator was appointed. In the meanwhile, after this, Rishabh filed a suit against Aston Field and Amit Shah, alleging fraud and stating that the sale and purchase agreement is vitiated by fraud and thus void, and asked for refund of its money that it had paid to Aston Field, and asked for recovery of 32 crores. Aston Field and Amit Shah then filed a Section 8, which Nusrat explained, the new Section 8, asking that the reference of the dispute should be made under all the four agreements under the Dante agreement, even though there was no arbitration clause between Rishabh and Aston Field, and they asked for consolidation of the disputes under one arbitration. The Supreme Court, in this matter, analyzed the facts, and of course also analyzed the chloro control decision, where of course the court cited chloro control, the principles of chloro control. I will just read out from the decision that the court will examine the exceptions where the arbitration agreement is extended to non-signatories. We'll examine these exceptions from the touchstone of, number one, direct relationship to the party signatory to the arbitration agreement. Number two, direct commonality of the subject matter. And number three, the agreement between the parties being a composite transaction. So, of course, relying on chloro control, the Supreme Court expanded the concept of the arbitration agreement itself to say that Amit Shah is the promoter and controlling man of both Dante and Aston Field. Juvi and Aston Field disclosed, so in both the agreements, which was with Aston Field as well as Juvi, the purpose for onward lease to Dante was stated. And in fact, Dante came to inspect the goods which were supposed to be purchased. And Supreme Court concluded, therefore, all the four agreements are integrally interconnected, and the Dante agreement is only a follow-up of the three agreements. And the three agreements, other than the equipment lease agreement, are ancillary to the main Dante agreement. So the Dante agreement, which was the main purpose, which is delivery of the plant to Dante, was considered as the main agreement. And the Supreme Court therefore concluded that, even though there is no arbitration agreement between Rishabh and Aston Field, the dispute between the parties can be resolved only by referring all four agreements and parties thereon to arbitration, and the parties uh, can be covered by arbitration under the main agreement. So therefore, what emerges is that in a regular construction environment, where you either have an employer which gives an EPC contract, or an authority which gives a concession which is then subcontracted, we have other parties also in play, whether they are guarantors, there are lenders, right? There is state support agreement. And therefore, the arbitration agreements need to be studied very, very well before you kind of launch an arbitration, because there are significant issues that will emerge depending on how the entire agreements are relayed. Like, we could give you several more examples of financing also, where guarantors have been roped in. But therefore, when we launch an arbitration in a construction environment, we have to be very, very clear now under the Indian law to kind of see that we examine all the agreements. Therefore, when we are drafting an arbitration agreement, it is important that the person who's drafting has access to all the other project agreements or related projects agreements. We used to have a concept of step down clauses, which is again very important. The process of arbitration invocation under all the agreements is required to be examined. Back-to-back basis or equivalent project relief clauses need to be structured with caution, especially where we have pass-through clauses. We'll see a very good case law coming up, a case study where back-to-back basis was permitted and was not permitted in both cases. Especially because our Section 7 now captures in the new act captures the incorporation by reference provision. So the moment in a contract we say that this contract is on a back-to-back basis, what we are doing is we are getting the main contract's arbitration agreement into the subcontract, or into the contract into which the reference is brought in, which is under Section 7. So I think the arbitration agreement gets therefore amended. In fact, in a very recent case in 2015, the Supreme Court, in fact, emphasized the impact of inconsistent arbitration clauses. And I'll read from this judgment, 2015 Supreme Court, where the court recorded the appellant's expressed fear being that while its obligation to pay, as sealed by the award in favor of the subcontractor in the first arbitration, would be sustained, the award in its favor against the employer, if heard separately, would possibly be set aside, leaving it uncompensated and liable to pay the subcontractor the claimed amount. Although in this case, in zonal GM, Supreme Court held that the contracts were separate, they could not be brought together. And there was no back-to-back relationship because, the contract was not referred properly into the main agreement. Although the intention was there, they said that only the technical clauses were incorporated. Only the step-down provisions that happened only qua the technical provision. So I think the arbitration agreements in effective construction management are very important, and we need to be very, very careful when we study these at the stage of invocation of arbitration. Nusrat?
Thank you, Anand. Now, of course, one of the important management issue which arises out of any complex arbitration, especially construction, and I think aspect which becomes quite critical in the long run is the selection of an arbitral tribunal. This is there is enough material to read and assist, which I think parties who are involved should also get educated. Besides, of course, the lawyers who may already be knowing of these material, because that is very helpful to analyze what kind of tribunal would you like. Because on the if you do not have a right tribunal to address the issues, especially in construction disputes, the complex issues, that can lead to a lot of issues during the arbitration process. So many countries have various forms by practice. Many adopt what is internationally accepted, and I think there are various ways of going about it. What you want at any point is a tribunal which can appreciate the complex issues which arise in a construction arbitration, in a construction dispute, and can deal with it effectively. Now, therefore, some of the criteria which you should be looking at is with reference to the experience in the industry, his experience as an arbitrator, his experience in law and relevant legal concepts pertaining to the dispute. Since construction disputes, especially the complex one, will throw up a whole lot of documents and will also have a list of witnesses which will have to be managed well. So therefore, you need to ensure that strong case management skills are set up. And today, fortunately, because of technology, you can do several things. Then normally, since we are talking about a complex dispute, one member, a sole arbitrator is never suitable. Therefore, you would like to opt for a 3-member panel. And at least out of the 3-member panel, you should try to have one technical member. That's important. We've seen cases in one of the matters which dealt with a certain technical aspect on a construction issue, where there was a requirement to test the soil, where the tribunal, though we produced an expert's report which proved the issue that was before the tribunal rejected it and did not take it on record and did not use that for deciding the issue at hand. Of course, when the award was challenged by us, it was immediately set aside, quite obviously. And of course, the court also noted the fact that it did not understand why the tribunal had not accepted the technical expert's report. So it's quite obviously, if a technical member is not there, as I said earlier, then it raises an issue whether the arbitrator is in a position to appreciate the issues and has the understanding of the industry. Therefore, it's quite important to, while selecting the tribunal, and it's part of the case management, that you ensure that necessary homework is done at that point. Of course, what you also need to do is strategize to ensure that you have obtained all the required declarations. Your homework is done. Ensured that the arbitrator is impartial and is not conflicted. Today, we have the advantage in the Arbitration and Conciliation Act today, where independence and impartiality can be tested to a large extent under Schedule 5 and 7, and with a declaration under Schedule 6. Also, what can be done, which is also you can follow CIRB recommend, that is the Chartered Institute of Arbitrators, recommends also an interview process, but also sets out what requires to be asked in the interview process. You cannot ask on the merits of the matter. You cannot discuss the matter. So you have to be careful as to what exactly you need to prepare yourself before approaching the arbitrator if for an interview. It is important to understand that if the interview process is not handled properly, that could become one of the grounds for opposing for challenging the award. So I think that's so I think what we have in what we have done in our experience, we set out an agenda right at the outset before the interview, so that allows the interview process to be a matter of record, and does not allow later on to create confusion between the parties. Of course, one or three arbitrators, I think, when we are talking about complex construction disputes, I think it's a given that you should look at three arbitrators. Quite obviously, three arbitrators allows three minds to work and apply their minds in a much better and a much more effective manner versus a sole arbitrator. Of course, then also you need to apply your mind to ensure that you normally the institutional arbitration, this is normally comes in when you are drafting the arbitration clause. You need to ensure that the institutional arbitration which you select has good processes in place, has proper case management processes in place, etc., to ensure that your dispute is managed well by the institution. So it's important that an appropriate institution is selected during the drafting stage. Autonomy and fee chargeable by arbitrators. I think this is one of the things which was dealt by Gammon engineers on with reference to which fees are basically saying that there is an autonomy insofar as what the arbitrators can charge insofar as their fees, as long as it is agreed by the parties. To the next slide, Anna. Yes. Much can be spoken on the multi-tier dispute resolution clauses, which constitutes, and this is one of the frequent applications that come up before the tribunal, whether the arbitration has been, whether the arbitration is premature or not. And there are two aspects of a multi-tier dispute resolution clause. And one is when at the drafting stage, when you have the clause drafted in a manner which allows you as a party, especially in complex arbitrations, there are stages which allow it to go through a process before the matter is referred to arbitration. Whether normally we would find there would be a negotiation clause, there could be a mediation clause, there could be expert determination, there could be a DAB, and there could be, and thereafter, pursuant to a DAB, the matter could be referred to arbitration. So in a multi-dispute resolution clauses should be, what we need to ensure should be constituted a single arbitration agreement rather than, especially when there are several agreements which exist, you need to ensure that you do not have different processes laid down in different agreements. Impact of accepted matters, I will leave Anand to deal with it in his next slide. I think another important point, what we have seen in many clauses, is to have time bound, which we recommend is to have time bound pre-contractual compliances before invocation of arbitration. So therefore, any pre-contractual compliances that are required, there should be a specific time period, whether it is 30 days, 60 days, 90 days, there should be a specific time provided for it. Since if there is no time provided, it leads an open end, which thereafter creates more issues before the courts and becomes a matter of dispute. So it's recommended that the time is clearly stated, and also it ensures that the process runs through a more structured manner. Also, you need to check if parties have not waived or deemed the enforcement impossible through their conduct. I mean, you can, if you have waived any of those rights by your conduct, maybe by an email, ensure that once there is a dispute which has been decided, there is a person, a contact person who within your company deals with issues that have arisen instead of several people dealing with it, because you may unknowingly end up waiving any of the processes, processes which would lead to more problems than anything else. So therefore, it is important that you set up a process whenever dispute has arisen, that you ensure that one person, contact person, is deputed to deal with that particular dispute. You want to take the next slide, Anand?
Yeah, sure. So I think we came across this very interesting case of 2015 Supreme Court, which was for L&T and Scope, which is the Scope complex in Delhi, which is the government machinery sits there now near Jawaharlal Nehru Stadium, if people have been to Delhi. So over here, this is a very interesting case of pre-contractual compliance. It's not the regular tiered process. But over here, what had happened was L&T had won the contract to construct the Scope complex in Delhi in 1980s. And while L&T retained the civil works, it had given a subcontract for the finishing works to a subcontractor. The subcontract was on a pass-through basis, on a back-to-back basis. So the entire scope of work for finishing went down to the subcontractor. The original contract provided insofar as arbitration was concerned that the subcontractor could receive payments only when payments were made by Scope to L&T. So a subcontractor's payments are subject to payment. All questions of disputes between L&T and the subcontractor were to be referred to arbitration. If subcontractor won the award, the subcontractor was not entitled to payment. L&T had to raise the subcontractor claim, which was adjudicated in favor of the subcontractor to Scope. And then only if L&T won the arbitration against Scope and on receiving the payment was L&T supposed to honor the subcontractor award. So this is the construct that was agreed under the pre-contractual compliance for the award process. What happened was the subcontract was amended. The subcontract was amended to say it was made more linear and easier. They said that now if there was a dispute with respect to the scope of subcontract, L&T would immediately raise that issue with Scope, and the matter would be fought as if L&T and the subcontractor were together fighting Scope. They will collaborate in the dispute resolution process, and there would be sharing of costs proportionately. And the decision that is finally decided under the Scope L&T arbitration will be binding on both the parties. It was not referable to arbitration again as to allocation or the proportionate sharing. It was yet again amended after more money was spent that any claim received under this arbitration between Scope and L&T would be now split 67-33. It was once again amended where it finally agreed that, okay, from here on, whatever are the issues, we will not raise them to Scope. We will collect them until the completion of the project. and then in the end we will do one arbitration. So with these facts, the construction of the scope complex got completed in 2002. Sorry, yeah, it got completed in 2002. And then in 2004, finally, subcontractor filed a Section 11 petition saying that, please appoint an arbitrator under the first subcontract agreement, arbitration clause, claiming that it has survived because L&T had made no progress with scope. It had not referred the matters to scope at all. And therefore, because it had not referred the matters to scope, the original arbitration clause will survive, and I, the subcontractor, have a right against L&T. L&T contested this position and said there could not have been any arbitration between the subcontractor and L&T at this stage, because while the works were inaugurated and everything was happening, the final payment was yet to be received. So therefore, the L&T's contention was that the works have still not been completed. So the Supreme Court, after analyzing this long pending dispute for more than 10 years, it was fought in courts, came to the conclusion that in the first instance, the subcontractor claims are to be taken with scope. So there is a pass-through. L&T has to submit the matter to scope. Subcontractor to collaborate in pursuing arbitration with scope for joint fight. Only after award is rendered in the L&T scope arbitration and something remains which may qualify as a dispute between the subcontractor and L&T is arbitration possible. But with this agreement in place, the Supreme Court held the original subcontract cannot be invoked at this stage because the final bill after revision was submitted only in 2012 and L&T has kept the bank guarantee valid. It directed that scope settle the final bill expeditiously, and presently the subcontractor did not have a right to raise arbitration against L&T. It rejected the application of Section 11, and it said scope has to finally settle the final bill within 2 months. Subcontractor claims if the subcontractor claims are not addressed in the final bill, then L&T will be obligated to then fight with alongside the subcontractor with scope. And if L&T doesn't do that, then the original subcontract contract of clause 25 of that agreement comes into force. So this was very interesting where, in this case, the pre-contractual compliance was taken to a different level. The original subcontract was held to survive in case L&T did not do the pass-through of the claims. But till the time L&T was doing the pass-through, the subcontractor was held bound to the amendment agreement and said that the pre-contractual compliance has not been done, therefore you cannot invoke arbitration. So it was a very interesting and of course much more complex than a multi-tier process. The regular DAB clauses, I'm sure all of us have seen. So one variant is this, where of course the good faith discussions between the parties have to be conducted first, and in case the discussions do not result in any decision or amicable settlement, then it can be taken to arbitration. Another scenario is where it is referred to mediation, and if mediation is not successful, then it is referred to arbitration. Of course, over here you would note in this clause, timeline is missing. So therefore, this clause is not a good clause. But in any event, a mediation is also one of the methods. And then we have the DAB method, where the parties are asked to settle their dispute by appointment of a dispute adjudication board. And if either party is dissatisfied with the DAB's decision, then either party may, within 28 days of receiving the decision, give notice to the other party of its dissatisfaction. Where notice of dissatisfaction has been given, the party shall attempt to settle the dispute amicably before commencement of arbitration. And if the dispute is not settled amicably, it shall be finally settled by arbitration. So this is again a standard clause which we see normally of a tiered process. Few judicial precedents of significance. In United Insurance, the Supreme Court held about a tier process, saying that it does not need special emphasis that an arbitration clause is required to be strictly construed. Any expression in the clause must unequivocally express the intent of arbitration. It can also lay the postulate in which situations the arbitration clause cannot be given effect to. If a clause stipulates that under certain circumstances there can be no arbitration and there are demonstrably clear, then the controversy pertaining to appointment of arbitrator has to be put to rest. So the Supreme Court said that the process has to be followed and it has to be stuck between the parties. And in Visa International, the Supreme Court observed that letters could be exchanged and inferred that attempts were made for amicable settlement. So in a tiered process, Supreme Court said even like the through letter exchange of letters, we can say that attempts were made. There is not necessary that a meeting needs to be held. And of course, in 2019, we have seen that NHAI has also implemented the compulsory conciliation for all NHAI disputes by formation of 3 conciliation committees. Coming to accepted matters, this is again one of the pre-arbitration issues that need to be seen. Where a dispute is referred to arbitration, the first aspect, of course, is the jurisdiction of the tribunal. And where we have clauses which read somewhat like this, where it says, in the event of any question, dispute, or difference arising under this agreement or in connection therewith, except as to matters the decision to which is specifically provided under this agreement. This is one way it is written. The same shall be referred, yeah. Or it can say, the arbitration clause can contain the words except where otherwise provided in the contract. Or we have also seen in a lot of government contracts where we say, the independent engineer or the owner's engineer or the lender's engineer or just the superintending engineer, whoever is the engineer, his decision shall be final, or with similar words attaching to the finality of decisions of the concerned authorities. It accepts certain matters out of the arbitration. And unless a decision on the accepted matters is finalized, if the tribunal goes with the adjudication of such disputes, it would be a futile exercise. And ultimately, in respect of those claims that come under accepted matters, the award passed by the tribunal will be set aside. Couple of cases in Vishwanath Sood case, the Supreme Court held that if the arbitration clause contains the term contract, then issues covered by such specific clauses of the contract ought to be decided in the manner provided in such clauses and not by recourse to arbitration. And a more recent case of General Manager Northern Railway, of course, in this case, there was an accepted matter in the arbitration agreement, which said that provided that matters for which provision has been made in so and so clause number of the general conditions of contract, or in cases of special conditions of contract, shall be deemed as accepted matters, and the decisions thereon shall be final and binding on the contract, provided further that the accepted matter shall stand specifically excluded from the provision of arbitration clause and not be referred to arbitration. So accepted matters, again, when we are engaging in arbitration, we have to check for accepted matters also. And in 2020, of course, we have had the ONGC Mitra Guha decision, where the Supreme Court held that when the parties themselves have agreed by virtue of specific clauses in the governing contract that the decision of the authority, which is anybody other than the arbitrator, in respect of certain specified disputes will be final and binding, then such disputes are accepted matters, and the correctness of the decision of such authority cannot be called in question in arbitration proceedings. Although the court said that you could raise it in a civil suit if you are not happy, because it's for these matters there is no arbitration agreement, but the court said you could always file a regular suit for these matters. So this is again very important in your pre-arbitration strategy. Then when we come to the scope of the dispute, I think we need to also judge whether the dispute itself is arbitrable or not, and does it need to be sent to arbitration. So I think our section 2 subsection 3 provided that certain disputes may not be submitted to arbitration. And of course, section 34 subsection 2 B and 48 subsection 2 also provide for The setting aside or refusal to enforce an arbitral award if the subject matter of the dispute is not capable of arbitration under law. And so basically, after the Vidya Dharolia decision, arbitrability can now be seen as a Vidya Dharolia or the post-Vijay Dharolia time zones. So for the pre-Vidya Dharolia, basically, Supreme Court in Booz Allen carved out 6 categories that were not arbitrable. So if our dispute gives rise to criminal offenses, or of course in construction we don't have matrimonial or guardianship matters, or insolvency and winding up, or testamentary or eviction or tenancy. And then in 2016, of course, in Vimal Kishore, Supreme Court added trust deed also. So I think those were the original category. And after Vidya Dharolia, I don't know why I'm calling it Vijay Dharolia, there was a fourfold test to determine an arbitrability of a dispute. So the first was actions in rem that do not pertain to subordinate rights in personam, and that arise from rights in rem. So basically, rights in the public field cannot be referred to, cannot be sought remedy under an arbitration proceeding, or affects third-party rights, have erga omnes. Erga omnes means, the common people at large, and requires centralized adjudication, and mutual adjudication would not be appropriate. Relates to an inalienable sovereign or public interest functions of the state, or is expressly or by necessary implication not arbitrable under a specific statute. So let us say the domain of those disputes is reserved for a specific tribunal. So it is pertinent to point out that these categories provided in the Vijay Dharolia case are not exhaustive. And recently in Eduskills decision in 2020, Justice Rohinton set out in detail, about fraud also. And it relied on various judicial precedents, including Justice Sikri's Ayaswamy's decision, and said that, serious allegations of fraud vitiate the arbitrability of a dispute. This is the test that it set. And serious allegations of fraud arise only if 2 conditions are satisfied: when the arbitration agreement itself cannot be said to be existing, or allegations are made against the state or its instrumentality of arbitrary, fraudulent, or malified conduct, thus necessitating the hearing of the case by a writ court, in which questions are raised which are not predominantly questions arising from the contract itself or breach thereof, but again questions which are arising in the public law domain. So serious allegation of fraud would therefore mean which is beyond the 2 parties involved in the matter. And fraud as between the 2 parties can be referred to arbitration, was what Eduskills said. And it enlarged the scope of what can be presented before the arbitrators. But if it involved a public function or a public body or a public law domain, then it has to be referred to court. That's right.
Yeah. Anand, I was just wondering, since we are now running out of time with regard to case management conference and document production and management, maybe we can between us take this quickly because we have a couple of more topics left.
Sure.
Right. So I think I'll just kickstart it, and then maybe you can also chip in, right? Yeah. So I think when we talk about case management, it cannot be emphasized more that for a construction dispute, it is of critical importance of what a case management conference can do in terms of how the arbitration process runs in the future. This allows during the case management process, it establishes a formal process and organizes the whole arbitration proceedings in a manner which allows you to understand how the arbitration is going to move forward in the future. Now, some of the in the case management that can be ascertained is you can, in the case management conference, discuss whether there are organizational charts required, layouts required, details of the construction, certain aspects which would be required by the tribunal, definition of the claim or an issue. Then also you can ascertain what the jurisdiction of the tribunal will be, identification of the parties, and represent whether all pre-arbitration contractual compliances have been made, nature of claims raised and limitations thereunder. Disputes are pre-decided by DAB or DRB, whether notice of dissatisfaction has been provided. As you can see, these provide us, by having this case management conference, a lot of these issues can be ironed out at the early stage, which really helps in proceeding with the arbitration more effectively. Next slide, Anand. Next, with reference to terms of reference, the tribunal should normally drop the first terms of reference upon receipt of the request for arbitration and its respond or case filed from the institution. Normally, terms of reference should comprise of description of disputes, set forth the scope, authority of the limits of authority of tribunal, full name and description of the parties and arbitrators, the language of arbitration and translation protocols, summary of parties, limit on page numbers, include reservation of list of future claims where a party is not in a position to refer all its claims to arbitration, such as pending, if there are any pending disputes before the DAB, or impact is still unknown, though the default event has already occurred. So therefore, this should be covered in the terms of reference. Any applicable procedural rules that are required to be followed, etc. Next slide. The terms of reference can also have the estimated claimed amounts. List of issues may be included at AT's tribunal's discretion. True issues emerge as soon as possible, since after finalization of issues is detrimental to speedy resolution, and therefore you want to avoid jurisdictional challenges at any stage. The preliminary list can be agreed, which can be refined at case management conference. Issues can be identified that need to be resolved by agreement between the parties or the experts. Identify issues that can be resolved solely on the basis of documents rather than oral evidence or legal arguments. This really provides a lot of assistance once you do that. Procedural rules. Parties are free to agree on procedure to be followed by tribunal in conducting its proceedings. Not bound, since Civil Procedure Code and the Evidence Act are not applicable to the Arbitration and Conciliation Act, but however the principles need to be followed. So this allows a leeway to the parties to decide on the procedure which can be followed. Soft laws can be followed in terms of using the IBA guidelines for taking evidence, etc. So these can be agreed at the early stage. Anand, do you want to take the documentation management?
Sure.
Yeah.
So I think one of the more important stages in a complex arbitration is the first case management conference, where of course the first procedural order and the procedural timetable are stitched together. Basically, it establishes the process of the arbitration proceedings, and it is here that the parties can play a big role in discussing various case management techniques. So, for example, whether we can bifurcate the proceedings into partial awards on key issues. We normally see a split across jurisdiction, liability, and damages. We could also have settlement awards being discussed, so parties can identify issues that can be resolved by agreement. The arbitral tribunal can inform the parties that they are free to settle, and where agreed, of course, a settlement award can be drawn up. Identifying issues that can be taken solely by documents. we can to some extent agree to reduce the time by doing telephone or video conferencing for procedural hearings, etc. Site visits can be thought of and planned very early in the day rather than towards the end. And for example, availability of video recordings of site construction, is something that is a tool which is available to prevent, like, if that is available to a good value, then site visit could be saved. Of course, there are issues of confidentiality and, a party giving evidence against itself in such cases. There is also the latest Section 31A, which now provides for the rejection of a reasonable offer. And I'm sure when we talk of the international side, we will discuss the concept of sealed offers. But now in India, I think the without prejudice save as to costs, settlement offers are being given. And our Section 31A3D now provides for this to be taken into account, that if a party rejects a reasonable offer. And also, the at this stage of the case management conference, it is of great importance that it is asked that if the parties want to tender, experts' evidence or not, and the tribunal to assess whether it is required or not. Subsequent CMCs, of course, can be fixed to narrow the issues as we come across them, to define further evidence, and to isolate any preliminary issue prior to the main hearing as it emerges. Organizing a pre-hearing conference just before the hearing is also sometimes good, rather most of the times is good, because the arbitrators can indicate to the parties issues on which they would want the parties to focus, having gone over the process. And I'll take the document management issue here only because I think it is also good for the parties to tell the arbitrators what the arbitrators must read, what is good for them to read, and what they cannot can omit for the purposes of the hearing. And at the pre-hearing case management conference, of course, parties can take stock of the progress of availability of the arbitration tribunal's appointed expert report, and also take assistance of the court in case evidence has to be obtained under Section 27 of our Arbitration Act under Part 1. So do you want to take document production, or can we just?
I think we are probably in the last few minutes, and
so I think let's do the hot tubbing
yeah.
Because I think we have done most of the. You could reduce.
Yeah,
I think we can splitting of awards.
Can go further. I think you can skip this.
Yeah, so I think hot tubbing is a new concept, very recent as 2019. This was over to you.
Yeah, I think hot tubbing is actually a colloquial term which has actually come about from. It has originated from Australia, and which is now, of course, caught on and is a common word across the world in the dispute world. And it's quite popular in terms of in arbitration proceedings. What does hot tubbing do? Basically, if you do not use the colloquial term, we would use a concurrent evidence or a joint evidence. But basically, you want to put the diagram there so people can probably appreciate how it proceeds. So this is something which is now also recognized by the courts, and Delhi has in fact amended its High Court rules and included it in Chapter 6, read with Annexure G, in its High Court rules. So therefore, hot tubbing now is officially a recognized concept in India. So what really happens, to be simply put, that you have expert witnesses of both sides put in a witness box together, where the arbitrator acts more like a the case director, or you could say where he manages the witness, and thereafter both witnesses give in front of each other their expert evidence. Now, what it also does is allows both of them to ask questions to each other. If you see, and the arbitrator, the tribunal will also allow the lawyers to ask the questions and ask the questions from the experts, and both. So basically, they get the right to ask questions from or cross-examine both the experts in front of each other. So there are several advantages. One of the advantages is that normally the expert does not end up being part of one camp, where normally the party appointing the expert, or the expert feels that the party appointing it makes puts some kind of a relationship on between the party and the expert. So this has become very popular and has been giving very effective results. So the fact that when you put two experts together and they are able to ask each other the questions, and then you can come to a conclusion and prepare a document on certain issues where both witnesses have agree on and versus what they have disagreed. So this allows to reduce and crystallize finally with helps the tribunal crystallize the issues which are disagreed between both the experts, and narrows down the issues that would be involved in the tribunal. So this is turning out to be a very effective way of being able to crystallize the evidence from the experts. And this has found popularity across the world. So it encourages now representative judges and experts to focus on issue prior to trial and to clearly identify areas of disagreement. Also what it does is saves a lot of time, naturally, by degree of focus and job of evaluating the disagreement, because by that time you would have ensured that the issues which are disagreed are clearly identified. So it makes it much easier when you're dealing with the issues as the trial proceeds. I think another one of the advantages which finds mention is a less adversarial environment also. I think we've run out of time. I don't know how this moves forward.
Shall we press on, or
does it work?
Mr. Hassan, how long do you think you would take to finish the remaining part?
I think we have 2 points: virtual hearing and enforcement. So
we could select a few out of them rather than take all of them.
Yeah, maybe we could just run through it in like a minute or two,
Sure. Yeah, we can go to the next slide. I think, of course, we just wanted to mention the fact that pursuant to the, in how technology is being forced upon us today, and we have all adapted rather well. And today virtual arbitration, quite clearly we see amongst the practitioners, amongst all the stakeholders, we find that today virtual arbitration can take place quite successfully. Of course, we have mentioned several case law where though the legislation has been silent on what with regard to video conferencing, but it's quite obviously, if you refer to these judgments, you will find that it has been recognized.
Right. And then, of course, the guidelines issued by the Delhi Arbitration Center have been also issued or for virtual hearings. Virtual cross-examination, of course, continues to have a few concerns, but then it has been solved to a large degree with the virtual guidelines issued by the Delhi High Court, which provided for a remote point and a court point concept where there are two coordinators at both the ends. And of course, there is a camera control with the adjudicating body, and there is regulated access and no recording other than the court's recording that happens. And the availability of translator is also there. There is also the ODR infrastructure that is available with the Mumbai International Arbitration Center and the Bangalore and the Delhi Arbitration Center as well. Online case management is a concept where 6 firms have got together recently, international firms which have kind of come up with a module on online case management. We just wanted to touch on it. So basically, it provides for 4 stages, which is e-filing, case repository, end-to-end case management tool, and online dispute resolution. But I think it is more in the international domain yet to become, a piece of Indian law. And then, of course, there's the Green Arbitration Pledge, where which was started by Miss Lucy Greenwood, and it pushes for more electronic than paper to be consumed. Basically, the concept is that medium-sized arbitration leads to about 20,000 trees to be cut. Just to give you some sense of it, it's the entire Central Park basically being cut out. So, green arbitration and the Green Arbitration Pledge is something that is also married into the virtual virtual arbitration. Sorry. And then, of course, enforcement. Mr. Do you want to quickly run through in a minute?
Yes, also? Please. Yeah. So I think the amendments insofar as Section 34 is concerned, where basically the Arbitration Act was amended to reduce the intervention of the courts and specifically in terms of narrowed the scope of setting aside the award, in particular public policy, in terms of public policy. And public policy was narrowed down to be set out only if they were induced by fraud and corruption, in contravention of public policy in India, or in conflict with the basic norms of morality or justice. So, though an additional ground of patent illegality was introduced by way of Section 2A of Section 34 for setting aside a domestic award, it further provides that an award shall not be set aside merely on the ground of erroneous application of law or by reappreciation of evidence. So what the amendment of the 34 did, it first tries to narrow what public policy would mean in terms of, and only in 3 specific cases it could be invoked, and other aspect also, though the patent illegality was added, the judgments. Can we go to the next slide, Anand?
Yeah, sure.
Try to narrow down finally as to what public policy would mean in a Section 34 application. Understanding, I think it's important to understand what public policy would mean in 34 would be very different from what public policy would mean under when a foreign award is being enforced. So in any event, Supreme Court in SsangYong Engineering and Construction Limited has, while dealing in the case of relied upon what the public policy has defined in associate builders. In fact, Supreme Court in associate builders relied on earlier judgments of Renu Sagar, Saw Pipes, McDermott, and ONGC, and stated what would constitute fundamental policy of India. It held that merits of an award can be examined under the broad umbrella of public policy. It held that an award to be held perverse should be based on no evidence. Arbitrable tribunal should takes into account something irrelevant for making the award, and tribunal has ignored vital evidence. So it sets out these three aspects for the court to understand only in those cases that it could be held to be perverse, and the award could be set aside. So public policy has been substantially narrowed by this judgment. However, it's not perfect at this stage. I think, can we go to the enforcement of the foreign awards? I think you're just last slide. Go back. I think you're really hurrying it. I don't want to take much time. Insofar as enforcement of foreign awards are concerned, we have come a long way from the infamous judgment of Venture Global, where Supreme Court had erroneously asserted that the Indian courts had jurisdiction on foreign-seated arbitration and even set aside awards made in foreign-seated arbitration. Pursuant to the judgment of Bhatia, the full court decision by the Supreme Court in Balco actually set in motion the pro-enforcement regime by unequivocally overruling Bhatia and Venture Global. So this was actually from Balco. This was the first pro-arbitration step that was taken by the courts. This, according to us, was a turning point which reflected the change of mindset of the courts and the judgments that followed. Now, in fact, the recent judgments of NTT Docomo, or can we go to the next page?
Yeah, sure. That's right.
Cruise City has now held it has narrowed down the public policy defense to an extent that it is almost it is now becoming very difficult for parties to raise public policy as an issue for non-enforcement of the award. It is also important to understand that under 34, an award can be annulled. Insofar as enforcement of a foreign award, insofar as foreign award is concerned, it is not insofar a different creature. It is insofar as only enforcement is concerned. So the award cannot be annulled. So I think this has been further clarified. In the cases by the Supreme Court. I think only with the last line I will close my discussion. In Vijay Karya, Supreme Court has cautioned the Indian courts against interfering with enforcement of foreign arbitral awards and reaffirmed by clarifying that the due process objections are only available under 48 of the Arbitration Act. And therefore, this pro-arbitration hands-off is leading to a landscape where today it is giving substantial confidence to all the stakeholders, especially international businesses. With that, I close my discussion. Thank you.
Thank you, Mr. Hassan and Mr. Srivastava, for sharing with us your thoughts and experiences. That was indeed an informative and enlightening session, and to note how the Indian arbitration landscape has changed over the past years and is increasingly coming in consonance with the international standard. All this coupled with the increasing adoption of technology, I think we're surely moving in the right direction to counter the complexities in construction arbitration. We only hope that this trend continues for times to come. So moving on from India to across the oceans, our second set of speakers, Mr. Mohan Pillai and Mr. Vijian Yang from Pinson Masons M. Pillai, who will shed light on today's topic from an international perspective. Mr. Pillai has over 3 decades of experience in commercial litigation and arbitration, particularly with respect to construction and engineering projects, both as an arbitrator and counsel. He's also qualified in Singapore and England and Wales, having previously held numerous positions, including chairman of the Society for Construction Law Singapore and president of the Singapore Institute of Arbitrators. He is presently a member of the Construction Adjudicators Accreditation Committee, Singapore Mediation Center. Along with Mr. Pillai, we have his colleague, Mr. Ang, who is an advocate and solicitor of the Supreme Court of Singapore and has been recognized as a qualified specialist in building and construction law. Mr. Ang has dealt with countless complex and high-value disputes and matters arising out of major international projects across Asia, Africa, and the CIS region. He is also a member of the Society of Construction Law Singapore and Singapore Institute of Arbitrators, and presently sits on the Singapore Academy of Law Construction Law Protocol Working Group. I now invite Mr. Pillai and Mr. Ang to give us their valuable perspective and continue this masterclass.
Thank you very much, Padmaja. I'm going to ask my colleague, Wee Jen, to kick off, and then I will come in the course of the time allotted to us. Thank you. Wee Jen, I think you're on mute.
पिल्ले का चला दिया मोहन पिल्ले
अभी जब तक वो कुछ बोलेंगे नहीं तब तक नहीं चला
नहीं बोल रहे थे उसके बाद में फिर ये कुछ करवा रहे थे
These technical difficulties commonly befuddle me. Thanks, Pamaja, for your very kind words. I'm not sure whether you can see the slide on screen at the moment.
No, the slides are not up.
Not at the moment.
Okay. I think we should just give it a bit more time.
Yes, they're coming up now.
Is it up now?
On screen, thank you, Vijay.
All right,
yes,
thank you, Mohan. Thank you, Pamaja, again. And on behalf of Pinson Masons and Pillai, Mohan and I are very pleased to be presenting the international perspective on managing complex construction arbitrations. I mean, as you would imagine, this topic alone could span days. And so we've tried to filter out, at least in this duration of our session, the more salient and perhaps the more common considerations that parties may face when mired in a construction arbitration. So I'm going to go on into the sort of the route map for today. We are unfortunately not as skillful as Nusrat and Anand in weaving interchangeably per topic. So Mohan and I are just going to split it just sort of down the line. So I will deal with the first two topics, key pre-arbitration aspects and interim relief pre-arbitration. And Mohan subsequently will deal with the following three, so managing dispute board decisions in arbitration, case management, as well as the merits hearing and how these could be managed sensibly in the process down the line. So I'm going to move straight on to the key pre-arbitration aspects. And there are three things I'm going to deal with. The first of which is the relevance of the seat. And I'm going to touch on this fairly briefly because I think given the kind of audience that we have, and it is indeed a sophisticated audience, I shan't spend too much time on some of these topics. Briefly, it's usually where the meetings and the hearings takes place. But one must bear in mind that the physical place, in other words, the venue or the location, is different from the seat. The seat here we're talking about is a juridical seat. I mean, it's colloquially called sort of the legal home of the arbitration. But it's different because this juridical significance plays into various things that parties need to bear in mind when in a arbitration itself. And that's because the seat will determine the procedural law. In other words, sort of the lex arbitri, as I think quite a lot of us would be familiar with. And this lex arbitri, in turn, determines the extent of local court involvement. For instance, what are the powers that a court may have to support an arbitral process? What are the grounds on which an arbitral award may be challenged? Is it based on errors of law? Is it based on public policy, something which our Indian colleagues from Ling Legal touched on as well earlier in their speech? More importantly, I think it also deals with what we call the supervisory jurisdiction of the court, which deals with the power of the court at the seat to set aside or annul the award, which is of course distinct from merely enforcing the award, which can be done in various other countries when enforcement is sought. So again, the seat is relevant in relation to all these aspects. The second subtopic I want to deal with is tribunal constitution, especially for complex construction arbitrations like ours. Now, Link Legal has talked about this earlier, and so I'm not going to delve into too much detail on this as well, but there are two things I'm going to highlight. And the first is what you see on the first bullet point there, is what reputation and experience means here. And this is reputation and experience of a tribunal member, not just broadly someone who has a construction background. I think you need to bear in mind what type of specific construction background this tribunal member has. So for instance, does he have specific experience dealing with specific types of infrastructure projects? Is it a rail project? Does it concern roads and highways? Does it concern plants? And even for plants, there are different types of plants. There could be power plants. There could be process plants that deal with raw materials. So all these kinds of things could be different. The second thing I'm going to touch on is temperament and judicial philosophy. And that's because in a construction dispute where we see fitted contracts in place, the temperament and a judicial philosophy of a tribunal member may become material. Is the tribunal member or the chair a strict literalist of the contract? And that's important because in fitted contracts, sometimes there are condition precedents. Well, there are always condition precedents which deal with notice periods, 28 days, 21 days, 14 days. Do we take a strict reading of these as condition precedents? How are condition precedents construed? Sometimes turns on the judicial philosophy and sort of the jurisprudential background of these tribunal members. So these are something to bear in mind when you're carrying out sort of research on who you want to appoint to your tribunal. I think Nusrat and Anand has talked about the following three factors: the number of arbitrators you may need in a construction dispute, the requirements of impartiality and independence, and of course, their availability as well. So the next subtopic is multi-party issues. And multi-party issues are fairly varied and they are very insidious in the way they permeate through construction disputes. So let me just set the context quickly. In complex construction disputes, it is not easy or common for a main contractor to undertake all of the contract works, especially when talking about contracts with a value of $1 or $2 billion worth of work. And so more often than not, it's more efficient financially and technically for there to be subcontractors on board. And so when we're talking about multi-party issues here, we're talking about the kind of interrelatedness that links the main contract to the subcontract and how changes in the main contract may affect the subcontract and the entitlements a subcontractor may have vis-a-vis the main contractor. And of course, in turn, the entitlements or the rights and obligations a main contractor may have vis-a-vis the employer, right? And so these could perhaps, these could potentially have far-reaching consequences on the risks, the liabilities parties in a construction project may undertake. And so these issues are, quite, I think, helpfully illustrated in the case. It's a very old case in Canada of Smith and Johnson brothers. And here, the main contract permitted the engineer, who obviously acts on behalf of the employer, to suspend various excavation works. Now, the subcontract, however, one line down, did not provide that main contractor that equivalent suspension entitlement, which also means, as you would imagine, when the main contractor suspended the subcontractor's excavation works, the subcontractor cried foul and basically claimed the damages for breach of contract. And was held by the courts that parties, the parties here referring to the main contractor and the subcontractor, could have made provision in their subcontract for what was to happen in the event of the engineer who belongs in the upstream contract, the engineer exercising his powers under the principal contract to obviously suspend the works. In other words, the main contract could have guarded against the risk that the subcontract's works would need to be suspended due to the engineer's instruction. And therefore, it was held that the subcontractor's claims for damages would be allowed. So what are the practical things you need to bear in mind in the context of a construction project like that? First, you have to ensure that you have a proper alignment of upstream and downstream risks, and that the risks upstream are properly passed down. So equivalent rights dealing with issues like variation, delay, termination, or as what you saw in Smith and Johnson, suspension rights need to be properly carved out in all your related contracts. So for instance, if your main contract requires 28 days of notice, then if you are the main contractor and you're in a bargaining position to negotiate the terms of the subcontract, you may want to say, I would like 21 days to be the notice period so that I would have sufficient time to pass on these claims upstream to the employer as the main contractor. Now, there is a second mechanism, and this is a fairly complex mechanism under the FIDIC subcontract form, which is what you see currently on screen, where there are three main parties here: the employer at the top of the chain, obviously, the main contractor, and the subcontractor. But this deals with a framework under the FIDIC subcontract form, which allows the subcontractor's claim against the main contractor to be suspended as the main contractor advances that subcontractor's claim upstream vis-a-vis the employer. And this is illustrated in the flow chart. There's quite a lot of things here on the screen, so I'm just going to take it sequentially down the line. Item number one is where the subcontractor first becomes aware of the event or circumstance which gives rise to a delay event or a cost event, entitling them to time or money. They have 21 days to give notice, as you can see on the vertical arrow on the right. Item number two deals with then the subcontractor's notice of claim, which needs to be made 21 days after the awareness of that event has occurred. Item number three explains how the subcontractor's fully detailed claim would then need to be put forward 14 days after the first notice of claim has been advanced. Subsequently, the main contractor who receives that fully detailed claim will have 49 days to determine whether or not the subcontractor is entitled to anything at all. Main contractor may say, well, no, I don't think you're entitled to anything. And as a consequence of that, line item number 5 comes into play. The subcontractor will then issue a notice of dispute. And this is where the framework for how the main contract rights and obligations meld with the subcontract. Item number 6 deals with the stage where the main contractor will then inform the subcontractor that your dispute involves issues which are also present in the main contract dispute. And therefore, if you see horizontally across the line at line item 6, the moment such a notification arises from the main contractor saying that this issue is a related one upstream, the subcontract dispute proceedings are suspended. And that's approximately for about 112 days there. You see in the vertical arrow in red font. What happens thereafter? The main contractor will then have to refer the subcontract dispute and the issues in dispute to the main contract dispute board proceedings under the FIDIC terms. And 84 days thereafter, the main contract dispute board decision will be released. In other words, you will see that for a total of 112 days there, the subcontractor's claims against the main contractor are sort of in abeyance, put on hold until there is a decision in the upstream contract vis-a-vis the employer on the rights and the entitlements that the subcontractor may have. And once the main contract's DAB decision is passed down, the main contractor could, if it's awarded sums of money, then provide those sums of money to the subcontractor. Or if the main contract dispute was not resolved, in a way which the main contractor or even the subcontractor agrees with, then the subcontract dispute unfolds as per normal. And that's where you see that shaded, that slightly shaded purple box on the right, where the main contractor may then refer the subcontract dispute to dispute board proceedings and vice versa. So that's another mechanism under the FIDIC form of subcontracts in which you allow the main contract rights and entitlements to be balanced with the subcontract form. So what are again the practical tips? One, as previously discussed, you ensure proper alignment of the upstream and downstream risks. The second one, which is the usage of the FIDIC subcontract form, was what we touched on briefly, because that involves a suspension of a subcontractor's claims in the entire sort of framework, including the employer's involvement. The third deals with a situation where you don't use the FIDIC subcontract. And that really involves some sort of sensibilities and practical sort of arrangements you may have commercially for subcontractor. So if you're the main contractor, you may negotiate a suspension of your subcontractor's claims in return for having the subcontractor assist you when you put forward his claims upstream vis-a-vis the employer. And that's another way you can bring in the subcontractor to assist, to facilitate a proper, comprehensive claim against the employer. I now move on to the second topic, which deals with interim relief pre-arbitration. And there are obviously, as you would imagine, various types of relief that could be sought and could be granted by the courts or the tribunal pre-arbitration. But what I'm going to focus primarily on here, in the interest of time, is injunctive relief against bond calls, performance bond calls, which are a common feature in construction projects. And obviously, performance bonds are typically provided by the contractor to the employer or by a subcontractor to a contractor. And these could be very sizable amounts of money involved, because on a project for, let's say, $1 billion worth, often, and are subject to negotiations, of course, the performance bond could be of a value of 10% or 15% of the entire contract value. And so if you imagine, if your bond is called by the employer, if you're a main contractor, that could have significant repercussions on your financial flow, your reserves, when you are funding and financing the construction works on the project. So these are commonly heated disputes between employers and main contractors and subcontractors. So what are the things you need to look out for when dealing with injunctive relief for performance bonds? First, you consider the law of the performance bond. What law governs the rights and obligations of the parties, because that is crucial to determining whether a party is entitled to payment under the bond. Is it a on-demand bond? Is it a unconditional or perhaps a conditional bond? What types of conditions are there? All that would be construed according to the law governing the bond. And I think more pertinently, the law of the bond deals or governs the potential defenses against a bond call, which dovetails nicely into the next slide. The grounds of restraint when you are seeking to prevent a performance bond from being called. And I'm going to deal with the UK position first, because that's commonly, well, I wouldn't say commonly, but it's one of the more frequent occurrences where you see bonds for international projects being subject to. And of course, given where we are based in Singapore, at least for Mohan and I in the Singapore office, I'll deal briefly as well with the Singapore position, which in many aspects mirrors the Malaysian and the Australian position as well. So in the UK, as you can tell, there are two grounds of restraint. One is fraud. The second is a breach of the clear and express terms of the underlying contract. So in other words, if you're a main contractor, you're seeking to resist a call on a bond, these are the arguments you may mount against a call. Now in Singapore, or Malaysia, or in Australia, there is an additional ground, in addition to the first two grounds that are present in the UK, and that's a concept known as unconscionability, which I'll come to in a very short while. So let's deal with the first ground, fraud. And fraud is established when you can show that the employer or the main contractor makes a call in respect of three things. One, you know that the call is false. In other words, it's made on false grounds, on false reasons. As an employer, you do not have belief in the truth or the properness of the call of the bond. Or you can be reckless. In other words, you call on the bond without regard to the truth or validity of the properness of that call. And those were sort of the doctrines and the legal principles that was articulated in a very ancient United Kingdom House of Lords case in Derry and Peake. It's been almost 2 centuries, but still resiliently good law. I mean, it didn't deal with performance bonds. It dealt with the principles underpinning fraudulent misrepresentation. But these principles for fraud have been carried through the years into even the context of fraud here when resisting performance bonds. So a brief case study on this. In what we mean by fraud in the case of CDN Research versus Bank of Nova Scotia. Here, the plaintiff sold goods to Iraq. The plaintiff was supposed to provide a performance bond. The goods were in fact delivered pursuant to the contract, but the defendant called on the bond. And as you would imagine, the demand was deemed fraudulent because the goods had actually been delivered, but the call was made on the basis of non-delivery. And so in other words, the defendant had called on the bond knowing full well, having receipt of the goods, that its call was false. And that's where fraud is clearly established. Right? So that's a very clear-cut case where fraud is made out. What then is the standard of proof? In the UK, the standard of proof is what we call the only realistic inference. And as you can see in the part in pale green, it means you need to demonstrate that the only realistic inference must be that the party involved could not have honestly believed in the validity or the properness of its performance bond demand. In other words, there is a requirement that you eliminate all other possibilities where the bond caller had honestly called on the bond. And that's what you mean by only realistic inference. You need to eradicate options which may demonstrate that the call had in fact been honest. What is the second ground we're talking about? And that deals with the breach of terms in the underlying contract, which prevent the beneficiary or the bond caller from calling on the bond. And this is treated as the second ground of restraint. And this is articulated in the case of Simon Carves, where Ensus here had engaged Simon Carves as they contracted to build a bioethanol process plant. The contract provided that the on-demand bond would become null and void on issuance of the acceptance certificate. Right, and as I can imagine, everyone would be guessing, the acceptance certificate was in fact issued, but Ensus nonetheless called on the bond. And so Simon Carves applied successfully to injunct the bond call. And the reasoning of the court was that if the underlying contract had clearly and expressly prevented the beneficiary from making a demand under the bond, then the court will restrain it from making that demand. And whatever academic jurisprudence there may be about whether this falls within fraud or not, the English courts were content in identifying that as a separate type of exception, a second type of argument to resist a bond call. So let's deal with the third ground, which is unconscionability, as foreshadowed earlier. And this is a bit more nebulous, it's a bit more vague. It involves elements, as you can see, which is tainted by bad faith, abuse, unfairness, a bit of dishonesty. So in other words, a bit of what includes fraud as well. And the reason why I say it's a bit more nebulous is because if you look at how the courts, well, at least the Singapore court explained this concept of unconscionability, is to really strike a balance between the competing interests that are at stake in the situations. Because the court recognizes there may be certain circumstances where the account party, the main contractor, for instance, resisting the bond call, cannot show that there was fraud involved. But there was nonetheless some elements of unfairness for the bond caller to nonetheless call on the full amount of the bond, or to, in the words of the court, realize its security pending resolution of the substantive dispute. And so therefore, this is sort of a bit of the middle ground between fraud and perhaps a clean slate where, there is complete honest belief that the bond was proper. It's important to bear in mind that the threshold for unconscionability is a lower threshold than fraud. I mean, it doesn't change basic things, which is what I've explained in the second bullet point here, which means if there is a genuine dispute over the merits on which the call is made. So for instance, if the call is made because the employer establishes, a case that you had failed to comply with contractual obligations, perhaps in building this particular structure or groundworks by a particular land, by a particular milestone, then yes, that is a genuine dispute over the merits of the contract, which permits the employer to call on the bond, especially if it's a unconditional on-demand bond, right? So the fact that this is a genuine dispute is not affected by your arguments of fraud or unconscionability. But as foreshadowed earlier, your grounds of defense will turn on the governing law of the bond. Because if the bond is governed by English law, then only the defense of fraud and breach of clear and express terms of the underlying contract would be available to the party resisting the call. Unconscionability will not be, because the UK doesn't recognize unconscionability as a ground. I was, if we had a lot of time, I would initially have wanted to sort of use sort of these case scenarios to explain these concepts by reference to actual cases, but I recognize that we have limitations on time. So what I'm going to do is I'm just going to run through various scenarios here to demonstrate how some arguments could have been successfully made. So if you look at scenario 1, if there is a call on the bond which alleges that the contractor was responsible for delays, even though no prior complaints had been made by the employer about these delays, then arguably a case of unconscionability is made out. And this is with reference to a case actually in Singapore, for instance. It's a Court of Appeal case where the facts bear those points out that I've made in the first scenario. The second one is a situation where there is a call on the bond with an honest but mistaken belief that the contractor had breached the contract, and this is not unconscionable. It's not unconscionable because there could have been genuinely a dispute on the merits, and there was actually, therefore, a call that was made in good faith, not tainted by issues of unfairness, dishonesty, or mala fides. The third scenario deals with a call on the bond, where the employer is alleging delays by the contractor despite express certification by the certifier that there was in fact no delay. And very arguably, this will not only establish a case for unconscionability, it would also establish a case for fraud as well, because you were calling on the bond despite knowing that your grounds for the call were false, or you were reckless as regards the truthness or the falseness of the reason for the call. I'm going to deal with the second subtopic now. Who do you approach for that injunctive relief? Is it the court or the tribunal? And to set the scene, I think one should bear in mind that even if there is a dispute resolution clause that provides for arbitration, the court nonetheless still has power to grant the injunction, even though a tribunal will be or will already have been empaneled to hear the dispute. And that's made quite clear usually in a lot of the statutory legislation, not just in the UK or in Singapore that I've put up on screen, but across many jurisdictions as well, which obviously see arbitration as a cornerstone in the dispute resolution jurisprudence. Right, so this basically just sets the scene. The next slide then deals with really, I think, the tactical or the practical implication of who do you approach. And the truth is, there is no hard and fast rule. But there are two things to bear in mind when deciding who to approach. One, the speed at which you can obtain an injunction. Two, the enforceability and effectiveness of that injunction. What does speed mean? Speed is essential because if you don't obtain the injunction swiftly, then it is pointless because the monies under the bond would have been paid out by the bank providing the bond upon the call by the employer. And so court processes, in England, in Singapore, in many mature jurisdictions, usually allow for a bond call, for an injunctive relief on a bond call to be made on an ex parte basis. In other words, only when counsel for one party, the applying party, is present, and that injunctive relief could be issued within 1 or 2 days. Arguably, if a tribunal had already been constituted, the tribunal may, and I say here it's a may, be able to grant an injunction at short notice. And so there's a possibility as well that a tribunal may be able to move quickly. There is the option of emergency arbitration, but that poses its own problems because even the emergency arbitrator route does take time. The SIAC rules, the LCIA rules, the ICC rules require about 1 to 3 days for the appointment of an emergency arbitrator. You then have the issuance of the decision within another 14 days. And you have another 15 days thereafter for a decision to be made. Sorry, I beg your pardon. In total, you have about 15 days, at least, for a decision to be made. And that may be too late if the monies had already been disbursed by the provider of the bond. And that obviously is comparative to the 1 or 2 days where a court may issue injunctive relief very quickly. The second consideration is the enforceability of or effectiveness of the injunction. Now, one must bear in mind that if you seek an injunction from a tribunal, that order, that injunction will only bind the parties to the arbitration. It will not bind the bank, who is usually the bond provider. And so therefore, there is a question of whether the paying bank, who is not a party to the arbitration, would comply with that order. If you compare it against a court order providing that injunction, the same may be said the bank may not be a party to a court order, but usually court orders carry with it very severe penal consequences. And so therefore, there may be a concern by the bank that they would be exposed to an allegation of assisting in the breach of a national court order, and therefore a bank may very well be more inclined to follow a court order ordering an injunction. So no hard and fast answer, as all lawyers would try to avoid committing to, but these are practical tips for one to bear in mind when you're at a crossroads in determining who to approach. The last slide that I have here deals with further considerations, which one must bear in mind, because if your application for an injunction to the court is made after the tribunal has been constituted, you would be required to prove exceptional or appropriate circumstances to the court. And for instance, in the UK, the court will only grant such relief if they consider that the tribunal has no power to do so. And the last thing to bear in mind is that when you approach the court and you wish to ensure that arbitration still remains the forum for dispute resolution between the parties, you may wish to ensure that you make clear that you are not waiving any rights to the prospective or the ongoing arbitration to avoid the other side from taking a very technical argument that you have dropped away from arbitration being the dispute resolution mechanism. That brings an end to my topics. I now hand over the session to Mohan, who will deal with managing dispute board decisions in arbitration. Mohan. Mohan, I think you're on mute.
Beg your pardon. Thank you. We've got 3 more sections that I'm going to be picking up. Sorry, Padmaja. So we're going to be picking up 3 sections. Padmaja, was there something before I started?
I was just trying to point out that you're on mute. That's all. Yes.
Right. Thank you very much. I know that at least some people are attempting to hear what I'm saying, which is always a good sign. So I'm going to be dealing with these last 3 areas, which is going to be involving arbitration case management as well as the merits hearing. But I'm going to start off by taking a look at managing dispute board decisions in arbitration. And really the key is a question of how to properly challenge an unsatisfactory dispute board decision in arbitration. Vijay, next slide, please. And these kinds of decisions, dispute adjudication board, dispute resolution boards, very commonly used in FIDIC forms. And I'm going to be taking a look at the Red Book, the 1999 edition, which is one of the more common editions of the Red Book for use. And one of the key decisions that arise in these circumstances relates to whether the tribunal's jurisdiction, when you are seeking to challenge a dispute board decision before an arbitral tribunal, whether that tribunal's jurisdiction has been properly engaged. And the answer varies according to the nature and the enforceability of the DB decision, i.e. whether the DB decision has become both binding and final, or whether it is simply binding. And the distinction here turns on clause 20.4. Next slide, please. And you see that here, which is the FIDIC Red Book 1999 extract of clause 20.4. And as must be, I think, apparent to many of you, the key is the filing of the notice of dissatisfaction. I think there's nothing really controversial about that. The intended effect is, pretty straightforward, and I try and show that in the next slide. And here I deal with the nature and enforceability of the decision and the distinction between a DB decision where a notice of dissatisfaction has been issued and one where it has not. But regardless of whether a notice of dissatisfaction is issued, as you can see, a DB decision remains binding on the parties. Where the notice of dissatisfaction makes a difference is whether the DB decision is final. And where the notice of dissatisfaction is filed and therefore it is not final, what happens is that it preserves the right of the parties to have it reviewed. And so in a sense, it's an interim decision because it's subject to review. Where you don't have a notice of dissatisfaction, the impact is that it renders the dispute board decision final and therefore not subject to review. As you will see in a moment, this has created some uncertainty around how best to take a non-final dispute board decision to arbitration. And this is a major issue because it goes to the heart of the arbitral process. Next slide, please, Vijen. And the reason is this: it affects the tribunal's jurisdiction. And to explore this, we need to consider the way in which the Red Book manages the route through which a party is required to go through in order to invoke arbitration. Next slide, please. And that is clause 20.6. And if you look at the screen, I've set out the extract from clause 20.6, and the language in the clause assumes a number of things. It assumes that before a dispute goes to arbitration, it is in fact first rendered by way of an opportunity for the DB to make a decision. You have to refer it to the DB. Why? Because you see in clause 20.6, it talks about a DB decision that has not become final and binding. Therefore, it assumes that a notice of dissatisfaction has been given. Now, once a notice of dissatisfaction has been given, clause 20.5 kicks in, because clause 20.5 then imposes a 56-day period, 8 weeks, for amicable settlement before arbitration can start. And you see, therefore, in the third bullet point, the general track in order to go to arbitration, which is a clause 20.4 reference to the dispute board, after which you have a clause 20.5 amicable settlement window of 56 days, then you proceed to arbitration. But there is an exception. And that exception is in clause 20.7, which gives you a shortcut to arbitration. Next slide, please. And I put up on screen here the FIDIC Red Book clause 20.7 extract. And as it's clearly stated in the provision, this clause 20.7 allows a party to leapfrog over clause 20.4, which is the DB decision requirement, and clause 20.5, which is the amicable settlement requirement. And that is apparent from the last line that you see from the extract in clause 20.7. It says subclauses 20.4 and 20.5 shall not apply. But the language of clause 20.7 is limited to only one type of DB decisions, the ones that are final and binding. And I've highlighted that in the clause. Clause 20.7 does not say that it applies to DB decisions that are either binding or final and binding. It doesn't say that. It simply says that the DB decision has become final and binding. So it doesn't contemplate any other type of DB decision. The question that therefore arises in these circumstances is this: what is the nature what is the status of a DB decision that is binding but not final? If the exception in clause 20.7 doesn't apply to such a DB decision, do parties then have to make a second referral to the DB under clause 20.4? In other words, the conventional track that we saw earlier, you go to 20.4 because there's a dispute, then 20.5, 56-day amicable settlement, then you go to arbitration. Can you use 20.7? There is some doubt if your dispute board decision is only binding but not final. So there is some level of uncertainty. Now, interestingly enough, this very question came up before the Singapore Court of Appeal a few years ago. Next slide, please. And this was the decision of the Singapore Court of Appeal in the Persero case. The full name is, PTPGN and CRW, involved in Indonesian project. It had come up before the Singapore courts a number of times, and that's why it's referred to as Persero number 2. And this was a decision which arose out of a dispute board decision by which $17.5 million was decided in favor of the contractor CRW. PGN, the employer, filed a notice of dissatisfaction. The result of that was that the decision by the dispute board for $17.5 million was binding on the parties, but it was not final because there was a notice of dissatisfaction. Now, CRW commenced arbitration proceedings on the DB decision, and they obtained an interim award on that DB decision. PGN challenged it, and they raised the very issue that we are now discussing. In other words, how do you take a matter that is a DB decision in which a notice of dissatisfaction has been filed so that it is binding but not yet final to arbitration? And PGN said CRW ignored what the contract required, and therefore the tribunal did not have jurisdiction. And this was the issue before the Court of Appeal. Next slide, please. And so what the Court of Appeal in Singapore was asked to look at was whether the proper thing for CRW to have done was to have referred PGN's non-compliance with the DAB decision again, meaning you already got a DAB decision. That DAB decision is not being complied with. But here was PGN saying, well, you can't take that to arbitration. You've got to refer it again to the DAB for a further decision before commencing arbitration. In other words, the route through which you saw the track earlier, 20.4, 20.5, and then arbitration. The Court of Appeal disagreed. Court of Appeal said that the failure by PGN to comply with the DAB decision, which was binding but not final, was itself capable of being directly referred to a separate arbitration under clause 20.6. And it dealt with the arguments by PGN as to a referral back to the DB by saying that would have been wholly superfluous. And it said that because the DAB had already been asked to look at it and the DAB had already rendered a decision, what is the point of going back? And there would be, the Court of Appeal said, additional delay, and it did not make any commercial sense to go down this route. But this decision, I have to say, has not been universally welcomed. Next slide, please. And there has been criticism, and that criticism has revolved around the strict reading of clause 20.7. And the argument that has been made is that clause 20.7 is very, very clear. It is limited to decisions of the DB that are final and binding. And that is the only exception that is recognized in the contract for a direct route to arbitration. And because it is limited to DB decisions that have to be both binding as well as final, it could not have applied to CRW's DB decision because a notice of dissatisfaction had been filed, thus allowing it to be binding but not final. And those who criticize this decision point, for example, to the 2013 FIDIC guidance memorandum. Now, interestingly enough, this memorandum, in fact, suggests something quite the opposite. You might think of supporting those who are criticizing this decision, because the memorandum says that FIDIC's intention all along was that a failure to comply with a binding non-final DB decision, in other words, the kind of dispute board decision that CRW had, the intention of FIDIC was that failure to comply with that kind of decision was capable of being referred directly to arbitration without going through 20.4 and 20.5. This was cited to the Court of Appeal, and the Court of Appeal relied on that. But those who criticize the decision say, well, you know, it's interesting that FIDIC talks about its intention in the memorandum, but what does FIDIC go on to say? FIDIC goes on to say in the memorandum that in order to make their intention explicit, that's the language that's used in the memorandum, they propose an amendment to clause 20.7. And the amendment to clause 20.7 is to expand the language in 20.7 so that 20.7 applies not just to DB decisions that are final and binding, but also to DB decisions that are simply binding. And that is why the language that is proposed to be changed was clause 20.7 is to apply to DB decisions, quote, whether binding or final and binding, unquote. And those that criticize the decision say, well, there you are. You do need an amendment to clause 20.7, and even FIDIC recognizes it. And therefore, if you are going to apply 20.7 in its existing form, it certainly cannot apply to anything other than a final and binding DB decision. Now, the 2017 edition of the FIDIC Red Book does incorporate this change. And it appears in clause 21.7. That is the equivalent of clause 20.7 in the 1999 book. But the 2017 edition now makes it very clear, clause 20.7 in the form of 21.7 in the new edition does allow a DB decision, whether binding or final and binding, to be referred to arbitration directly. But the question now is, well, how do you deal with the situation if you have got the pre-2017 FIDIC Red Book, the 1999 edition? And I've got some suggestions, and I deal with that in my section on practical tips. One is that the Singapore court's approach to the 1999 edition, as we've seen in the Pesero case, provides a safe harbor. Meaning, if these issues came up before the Court of Appeal or any of the courts in Singapore, because the highest court in Singapore is the Court of Appeal, the decision in Pesero 2 is the law in Singapore. And therefore, that approach will be applied. So if your contract provides for Singapore law to be the governing law, or if it's a Singapore-seated arbitration and the Singapore courts are the supervisory courts, you have a reasonable level of comfort that the Singapore courts will support a tribunal that says we have jurisdiction even if it is just a binding dispute board decision. In the absence of that, there is a risk of a possible challenge to tribunal jurisdiction, and therefore it is important for any party in that position to consider where is the seat of your arbitration, where is the enforcement court, because unless they are subject to being bound by the Singapore court, meaning a lower court in Singapore or the Court of Appeal itself in Singapore, some other court could take an alternative view. And if the seat is outside Singapore, that will also have an effect. And therefore, there is a bit of a strategic decision that is involved here about whether you might want, as a matter of precaution, just to make a second referral to the DAB, put up with the delay, but avoid the subsequent challenge to the jurisdiction. Of course, if you have the chance, you might want to amend clause 20.7 of the 1999 FIDIC Red Book, or better still, use the 2017 Red Book because it gets you out of this particular problem. I'm going to move on now to the next section, which is arbitration case management, and I'm going to be touching on a couple of topics. And Vijayan, if you can move to slide 47, you will see that there are a number of aspects that I cover in arbitration case management. There are 4 particular aspects. This includes issue lists, SCOT schedule, site visits, and document management system. But I want to start with where most arbitrations begin, and that is the procedural timetable. And one of the questions I want to touch on in trying to manage complex construction disputes is an issue of whether you should be seeking a full procedural timetable or whether a partial procedural timetable is going to be more helpful. And I'll touch on bifurcation considerations as well. Next slide, please. In terms of procedural timetables, although the institutional rules vary, and you can see that on screen, the ICC rules specifically and quite explicitly refer to the need for a procedural timetable in Article 24.2. The SIAC rules have no express requirement. In practice, however, it would be very unusual not to have a procedural timetable settled fairly early on in an arbitration. And the question then arises as to whether you want to deal with a partial or a full procedural timetable. And this question can arise particularly in complex construction disputes. A full procedural timetable, which you will find in procedural order number 1, which is right from the early stage of the pleadings right up to the merits hearing and closing submissions, can involve upwards of up to 20 procedural stages. Interestingly enough, the ICC published a report in 2019 dealing with construction industry arbitrations. One of the suggestions that was made in that report is that parties may wish to consider a partial procedural timetable option in larger cases. And the suggestion that was made is that this partial timetable should take the parties through to the end of the evidence being presented in terms of document production and in terms of factual and witness evidence, not quite the hearing. Don't make any further orders past that point. Bring the parties back and reconvene to consider with a further case management conference, but block out a window for the hearing right from the very start, but leave the steps after the evidence has been presented by way of the document production and the witness and expert reports to a later case management conference. And of course, we'll KIV, I think for questions, if we have time, what the real benefits of something like this might be. But if you take a look at how you get involved in this, and I think it's really, really quite important to try and deal with this. In my experience, what tends to happen is that most tribunals generally want to do a full procedural timetable. There can, I think, be, in very, very complex cases, possible departures, but I think parties really need to be encouraged to participate in this process. And therefore, getting parties' input at that stage is going to be quite important. And I see the way in which many tribunals deal with that in a 4-stage process. The tribunal generally will circulate, after an internal discussion between the tribunal members, a draft procedural timetable in which it sets out what the tribunal considers are the appropriate stages, but leave the timetable in terms of the timings for the parties to discuss. It will then send that to the parties in the 2nd stage, ask the parties to go away, think about it, and if they want to change the stages, to propose that, alternatively, work out a date for each of the stage after discussion with themselves. The 3rd stage is where the tribunal is then presented either an agreed set of dates or where the parties, and this very often tends to happen, have disagreements on how the procedural timetable should be managed. And the 4th stage is where the tribunal hears the parties, makes a decision, issues and signs off the procedural timetable. Now, there's a point there about float. This is not the float in the construction project. This is the float for arbitration. It serves the same purpose. It's an important practical point. It's not really a legal consideration, but it's a very real and practical aspect. It's quite interesting because if you look at the ICC 2019 report, and you'll find this in paragraph 9.4, they use quite interesting language. They say some latitude must be allowed for, and this is the words from the report, human frailty. I think tribunals that recognize this and provide a level of flow do so because they want to avoid significant disruption to the procedural timetable, especially anything that might put the merits hearing dates at risk. So in complex cases, it is not at all unusual to see a timetable that might contemplate 15 to 18 months, and there will be slippage that are provided for unforeseen events. In fact, you should really be providing for some foreseeable events. For example, parties may wish time to discuss possible settlement. So having buffer is really quite important, and most tribunals will, as a practical point of view, not compress the timetable so tight that the minute you've got spillover on one, you destroy the entire procedural timetable. So this float is quite an important practical point for parties to bear in mind. I move on now to take a look at bifurcation aspects. And there are many ways you can slice and dice this, of course. The most common, where you split the hearing, is between liability and quantum. But of course, you can have splits in a number of other ways, where you have the merits hearing being dealt with separately from what could be preliminary issues. And those preliminary issues commonly would include jurisdictional challenges to the tribunal or jurisdictional challenges to part of the claim that is being put before the tribunal. And that particular type of challenge may be because the party resisting it would say, well, you haven't complied with notice provisions in the contract. And if you haven't complied with these notice provisions, the tribunal can't have jurisdiction, and therefore the tribunal should deal with that early. So you can bifurcate really on that basis. But a tribunal that is faced with a question as to whether it should bifurcate is really going to be taking a look at this from a number of perspectives. I mean, what is the objective of trying to bifurcate a proceeding? And I think tribunals view that on the basis of whether the proposed bifurcation genuinely helps to narrow the issues. Because if you narrow the issues, you avoid unnecessary costs. But tribunals can often also be alive to the fact that a party presenting a disputed application for bifurcation may be trying to gain some tactical benefit to delay the arbitration. So, tribunals tend to be quite alive to that as well. How do you deal with a possible bifurcation? I mean, do you simply let the parties present this? If you're the tribunal, is it a scheduling issue, meaning you put it in the procedural timetable itself? I mean, this is really a matter, in my experience, of personal style of the presiding arbitrator or the chair of the arbitration tribunal, and the view that that individual takes in terms of how best to manage an efficient arbitration. Yeah, whenever I sit as presiding arbitrator, or when I'm on a tribunal, I do make it a point of including in the schedule a provision that parties should consider whether they want to make a bifurcation application, or for the tribunal itself to raise for the parties' consideration a possible bifurcation at the point where the pleadings have already been filed and the list of issues have already been formulated and presented. I mean, the key thing is that a conscious decision should be made before the arbitration moves too far ahead, because then you would have not been able to gain any of the benefits that a bifurcation would have been able to provide. I'm going to now move on to the next aspect of case management. Next slide, please. And here I'm going to be taking a look at list of issues and Scott schedules. Next slide, please. Again, you will see that there are some variations to the institutional rules. The ICC makes it a express requirement unless the tribunal feels it inappropriate for a list of issues. There is no express requirement in the SIC rules. That is a reflection of the tribunal being given a level of latitude as to how they want to run it. But in practice, it is a helpful tool that many parties and certainly many tribunals tend to consider. I think especially in complex construction cases, And this is usually considered at the point after the pleadings, where the parties have already set out their cases, set out
Streaming or
why,
Facebook group देंगे
from the respondent's point of
recording
view, the claim
streaming
is not
किसको
made out, and you can then see from the pleadings what the issues would be. In a complex construction case, it is possible that you will need to revisit
ये सर
and
बीच में काम
refine
कर रहे हैं
these list
ये
of
देखो यार
issues as the
ये
case
भी अपने
progresses.
बीच बीच
But
में
you might
काम कर
ask,
रहे हैं
what
वो
is the importance of formulating this at an early point?
इसलिए नहीं जाते
Well, I think it is important and helpful because it helps tribunal with one critical aspect of an arbitration where around which there can be many disputes,
ये तो इससे हटे
relevance.
स्क्रीन
And it helps tribunal deal with relevance when it comes to contested applications for document production, or where there is a challenge to a line of cross-examination as to what is the possible relevance of asking the witness this question. Well, if you've got a list of issues, it tells you what the parties and the tribunal should be focused on. And that helps you establish relevance for a number of things. And the last point I make on the slide is that it is important also for the award, because many tribunals use it as a guide when writing the award to ensure that their decision deals with all of the issues arising in the arbitration. I'm going to move on now next to take a look at some of the practical pointers on how to approach creating the list of issues. Obviously, if you happen to be involved in an arbitration, it is a good idea to seek to agree the list of issues with the other side. Many tribunals will prefer that. What you see on the slide in terms of the second, third, and fourth bullet points, they're reasonably, I think, and quite self-explanatory in terms of how you can sensibly divide up the issues. I do make a point about hearing duration and claim values. And that is relevant because it is a practical consideration. I think there has to be some sense of proportion that is needed when you are looking at the number of issues that you are presenting before a tribunal. I'll give you an example. In a recent arbitration, which contemplated a 3-day merits hearing, not a very substantial arbitration, claim values were about US $2.5 million. The parties submitted, and it wasn't agreed, there were all kinds of challenges around the issues, but they submitted something like nearly 50 issues with a number of sub-issues built in. Now, the tribunal sent the list of issues back to the parties, invited them to review, and said this is not proportionate to the nature of the claim or the number of hearing days that we've got. It is not practical. You need to review this and come back to the tribunal for a discussion. Eventually, the final list that was settled was brought down to nearly half the length of the original list. Also, my final point is where you've got a disagreement on issues, it is going to be helpful to provide the tribunal with some brief reasons for the disagreement, because the tribunal will then be in a position to decide how they want to try and manage the resolution of that particular dispute over that issue. I'm going to move on now next to Scott schedules. And this is a sample that you see up on screen from the 2019 ICC report I referred to a little bit earlier. This is nothing really new. It's a really useful tool when you've got a large number of individual claim items. And as you can see from the slide, it is commonly used when you've got variation claims or defect claims and a large number of them. And the key is obviously to tabulate these claim items in order to identify where the point of dispute is. Now, if you take a look at the example that is up on screen, this involves a Scott schedule for variation claims. And I've only put in one particular item here as an example. And if I draw your attention to the column that is marked number 5, it reads, and this is the respondent's response to the claimant's claim for this particular variation item. Respondent says, not extra. Claimant obliged to include excavation to any depth in its rates and was merely instructed to do what it had to do. So you know from that a decision is going to be required as to whether this is a variation. In other words, there is a challenge on principle. And the quantum, the question of how much should be paid for this variation, only arises if in principle it is a variation. So Scott schedules tend to help extract from a morass of information and pleadings a table that allows a systematic analysis of the claims, and the final column will be for the tribunal to then put its decision when it comes to that particular stage. I'm going to move on now to site visits. Next slide. I'm going to touch on this very briefly. Wijen, can we be at slide 55, please? One of the problems in my experience with site visits is time and cost. It can be very significant, and therefore it raises the question of whether you derive the utility, the benefits that come from that kind of investment. Now, there's some significant downsides to a site visit that is not properly thought through and not properly managed. It is very difficult for a tribunal to take any benefit from a site visit if the conditions that are currently on site are significantly different and of no assistance to the tribunal because the claim involves something which they can't see and which is not relevant from the current condition of the site. Very often during site visits, you have what I call private advocacy, meaning in the course of the tribunal being walked around, one party or the other tries to sneak in something into the ear of the tribunals to try and get his thinking more onto the side of that particular party. You really need to be quite careful about that. And of course, the timing of the site visit needs to be quite careful as well. If you've got the factual reports in, that is going to be really, really helpful. I'm sorry, there's a typo error. There should be factual report, not expert reports. But the expert reports, I think, can come a little later. But it is important to get the factual reports in, because if during the site visit you don't have the factual reports in, issues aren't clear, it doesn't really help in terms of focusing the tribunal's mind. And the tribunal may make one or two observations that parties may then take away and decide to tailor their factual evidence to try and fit in with one or two comments that they believe displays the tribunal's thinking. So that's not really going to be helpful. So if a site visit is going to be efficient, I really think it should take place after the submission of the factual evidence, but perhaps not necessarily after the final expert reports. But it's got to take place well before the hearing. So it is going to be a difficult question to answer, but if it is going to be decided that a site visit is going to be helpful, then my practical tip would be draw up a protocol document. And this protocol document should deal with issues such as who will attend the visit, who will be the party's representative who will be communicating with the tribunal, because you don't want 35 people, all of whom are talking to the tribunal at the same time, right? What is the extent of the communication between the tribunal and those in attendance? For example, will the tribunal be allowed after the end of the site visit to convene the experts together to ask questions? You want a program, you want timing, you want the route to be sorted out. So there are a number of things that are really going to be helpful to put into that protocol document. And really the reason for these protocol documents is to ensure that parties are treated fairly and even-handedly, and one party doesn't get some kind of unfair advantage. I'm going to now move on now to the last item in the case management section, which is document management. And Nusrat and Anand touched on this very briefly, and I'll be dealing mostly with the electronic aspect of this. So can I go to slide 57, please? This is not uncommon. Many arbitrations are now moving towards electronic bundles, and the benefits with large volume documentation, which happens with complex construction disputes, is obvious. Now, part of the benefits in some respects is really quite old world, nothing to do with modern technology. And it's really a question of how you choose to organize your documents. And I've put up some examples of how you would organize these documents up on the slide, factual, expert reports. You can even have issue bundles. And these are bundles which bring together documents that are relevant to a particular claim. And many tribunals find that especially helpful. Excuse me. But I think some of the real cost-saving aspects today come from new technology. So I'm going to take a quick look at an example of a Vincent Mason's MPLA on a very, very substantial arbitration. Next slide, please. And this is a software called Exhibit Manager. And what this does is that it requires you to create a project database of documents. But once you do that, it is able to pick up from this project database very quickly and very efficiently production of e-bundles. And interestingly enough, this allows, if you end up very late in the day having to insert a document, it will automatically update that document across multiple bundles. Obviously, this is not the time for a full demo, but I'm going to show you in the next slide a snapshot very shortly from Exhibit Manager from one of our matters. And you can take a look at that now. And this is slide number 58. It shows the creation of a list of exhibits and how the software creates paginated and stamped bundles of exhibits. There will be many other softwares that are available, but on a large complex matter, being able to locate documents and produce them in a way that is quick, fast, and cost efficient, will, I think, very often in complex construction cases require appropriate sort of technology. And this is just one example of that. And with that, I'm going to move on to the last segment of my talk at slide number 60. And this is arbitration merits hearing. Next slide, please. I'm going to be touching on 4 aspects of this: managing factual and expert witnesses, the hearing duration, chess clock procedure, and the award deadline. And let me move on very quickly because time is running on to the first of these, which is managing factual and expert witnesses. And it's slide number 62. As you can see, you've got what I put up at the first bullet point, which is sort of the conventional sequence of how witnesses are presented. You get the claimants presenting their full case, they do their factual witnesses, they do their expert, and after they close their case, you have the respondents presenting theirs, factual and expert. Many tribunals now have started to explore alternatives, and that alternative tends to revolve around presenting all of the factual evidence first, meaning both parties present all of their factual evidence. And then you have the expert evidence coming, but by discipline. And what you see in the third bullet point is an example of a procedural order from one of the arbitrations I'm involved in, where the tribunal made that order, which reflects what I've just presented as the alternative. Right? The tribunal says claimant to present their factual witnesses first, then the respondent's factual witnesses, followed by the cross-examination of the claimant's expert witness, and then lastly, the respondent's expert witness. In this case, there was only one expert each, so there was no real issue of the discipline. The benefits of the alternative approach. Well, I think that one of the things that I have found from the experience of doing arbitrations, which has adopted this alternative approach, is that when you have the factual evidence presented fairly early on before the experts come on in giving evidence, the tribunal has a full factual picture. They understand what are the points of key factual dispute before they hear the experts. Interestingly, this is also helpful for the experts because the experts also likewise have this benefit before they give their expert evidence. And the second point, which is you have the experts coming and giving evidence by discipline, that is really, really practically beneficial because it provides a level of clarity to the issues. And I think that in turn means you have better decision-making process by the tribunal. Next slide, please. I'm going to take a closer look now at experts. That's slide number 63. How best to manage experts and some of the best practices that we've come across. On to slide number 64. Some of the points about picking the competence is a given. But you also want experts that are independent. And by independence, I mean you have to make sure that your expert that is being used at the arbitration had no role in preparing and formulating the pre-arbitration claim documents, because that will compromise the independence of that expert. You also want an expert that is strategic. Strategic because experts help lawyers with cross-examination planning, help counsel deal with what are weak points in your own case. And therefore, you want a level of strategic thinking from your expert as well. Expert conclaves tend to be very common these days, where experts meet on a without prejudice basis, usually on the tribunal's direction, to see if they can narrow down technical points of difference. Now, this really requires quite careful preparation and planning. Why? Because you don't really want your expert to concede some key technical points of your case because your expert wasn't aware of how important this was to your overall case and concedes it in a conclave management meeting with the other side. So one really needs to be careful. And then, of course, there is the issue of what is sometimes referred to as hot tubbing. It gives an image that may not be particularly professional. So some people have come up with the alternative phrase witness conferencing. And essentially what that means is that experts of the same discipline give evidence at the same time in each other's presence. They're right there sitting side by side as the evidence is being given. Now, witness conferencing is very often tribunal-led. That means you need a tribunal that has got the right temperament and the right level of interest to engage with the experts right at the very beginning. It also means a level of interaction directly between the experts. So you've got to have an expert who has the confidence and the presence of mind to be able to respond there and then with his counterpart sitting on the other side. Now, the object of this is to actually try and moderate technical views. The assumption is that you are not, as an expert, going to present something preposterous when you know you've got a counterpart in your industry sitting right next to you. Now, there is a practical problem that I have discovered as counsel with witness conferencing, which I present there as counsel disadvantage. And that is when I cross-examine an expert, because this is such a specialist area, the answers that the expert gives me sometimes requires assistance from my own expert. So I will want my expert sitting by my side to say, actually, that particular answer he gave requires a follow-up question. And here's what would be helpful for you to ask. I mean, those kinds of input is really going to be helpful. If your expert is sitting in the box next to the other side's expert, as you try and get this information out, you won't have that advantage. So, one's got to be quite careful. And that is why I very often find that there's a bit of a tussle between counsel on the one hand, who doesn't want witness conferencing because he wants the benefit of his witness by his side on cross-examination, and a tribunal that sees the benefit of putting the experts together. And the tip that I would suggest as a practical tip in response to that is what I call a hybrid model. And the hybrid model brings both the conventional cross-examination of experts together with witness conferencing. And that is where you have the experts cross-examine in the conventional style by counsel with only one expert sitting there. And at the end of the expert evidence, the tribunal has liberty to call the experts back together by discipline for witness conferencing. That's one particular point that I would make in terms of a practical tip. One of the real issues that have arisen with sort of expert evidence is summed up by this oft-repeated image of ships crossing in the night, meaning the experts don't engage with each other on a basis that allows effective comparison. So I'm going to take a quick look at that in the next slide, which is on management of experts, the arbitration aspects of this. And this is where I think a number of matters within the party's control is really going to be helpful. Agreeing a list of disciplines fairly early on is going to be important, and thereafter a list of expert issues that will help avoid this ship passing in the night type scenarios. And a couple of practical tips that I thought you might find helpful, which represents, in my view, a lot of best practices internationally. Even before the first report is presented by the experts, there may be benefit in the experts meeting. And this is especially true of delay experts. So when delay experts present their reports, they will use baselines, they will be considering critical path networks, and they will have their own preferred methodology of analyzing delays. Now, if you've got a situation where the experts are using entirely different methods, it's no point one of them using a time impact analysis and then the other expert presents an analysis using a collapse as built methodology. And you can't really have a tribunal doing this comparison. So it's helpful in the early stages if you've got issues around experts presenting on evidence such as that, even before the first report, to have these kinds of meetings organized. If they can't agree on the methodology, what many tribunals will do is to say, we won't force you. We will allow you to use your own methodology, but you then have to ensure that in your report, you also include an alternative analysis using the other experts' preferred methodology. I mean, this is going to result in additional cost and time, but sometimes that's unavoidable. And after the first report is exchanged, you have these experts conclave where they try and narrow down the issues as much as possible. And then where they can't agree, you limit the reply reports to only those areas. But many experts will end up reaching agreement on many points at the end of the first report. I'm going to move on now quickly to hearing duration, and I will deal with this fairly quickly. Can I move on to slide 67? Tribunals have a responsibility to try and manage hearing durations. I mean, many rules provide for this, and it's really about economical, cost-effective resolution. And you see the rules up on the screen. And I've given two examples of where tribunals have looked at hearings and said, this does not justify an overly long hearing. $3 million dispute, oil wellhead platform, delay modification, commissioning issues. Tribunal said 3 days. On the other hand, a much more substantial claim, $90 million on a biomass power plant, which involved issues of delay, termination in the contract. The tribunal gave 12 days of split because it was a bifurcated proceeding. And in both of these cases, the tribunal used a chess clock procedure. And then I thought what would be really helpful is to try and deal with the chess clock procedure on the basis of not trying to describe it to you, because trying to describe a chess clock procedure is a bit like trying to describe an elephant to you through description of its various bits. Seeing it is going to be much better. So let me take you to slide 68, which sets out a procedure which is from one of the cases that I was involved in. This is a 3-day hearing. It's from 1 to 8 because there were overseas parties involved. But you can see the level of fine detail that you need to go into. So the tribunal works out how many hours it sits on a daily basis. It takes away time for housekeeping matters, works out what is the balance, and then it provides time for oral openings. And then it works out how many hours it has got left. On to slide 69. And you can see the timing that the tribunal has set up for the witnesses, including the experts and the factual witnesses. All of this is generally done in consultation with the parties, not simply imposed, right? And tribunals will confer with the parties before coming to any final conclusion on this. And now I'm going to deal very briefly with the award deadline. That's slide number 71. This is my last slide. This is obviously a matter of some considerable importance to the parties. The rules do deal with that. They provide timelines. In my experience, tribunals reasonably take up to about 3 months after close of proceedings to get the draft award out. There are, of course, always exceptions in hugely complex cases involving vast amounts of money. But frankly, anything that goes beyond 6 months after the close of proceedings would be cause for concern. There is a practical tip where you are dealing with an ad hoc arbitration. It's probably a good idea to flag this up quite early with the tribunal in terms of the parties' level of interest in wanting to provide a timeline for when the tribunal expects to release its award. And then you might need to come back to this a little bit closer to the hearing when the tribunal has a better sense of the work that is involved. And that brings me to the end of my presentation. Thank you very much, ladies and gentlemen.
Thank you so much, gentlemen, for sharing with us your thoughts and experiences. It was indeed interesting to note the similarities between the international perspectives and, the Indian law and the with respect to especially bond calls, such as the grounds on which one can seek an injunction, and more so with respect to the practical considerations to keep in mind whether to reach, approach the courts or tribunals. It was also exciting to keep in mind the valuable tips regarding case management and for merits hearings, such as laying out procedural timetables, bifurcation of issues, and at what stage, importance of laying out the list of issues, practical usefulness of the SCOT schedule, document management of experts. Thank you so much again. On this final note, I will release everyone, our speakers and participants, and urge them to come back fully charged to an exciting post-lunch session. As there has been some sort of spillover, we'll reconvene in about 30 minutes from now, which is at 2:40.
I believe, in the interest of time, I would also quickly introduce Kevin Nash, who is going to speak subsequently after Justice Sikri finishes the tribunal's perspective, because the arbitral institution's perspective will be covered by Kevin. Kevin, as many of you would know, is the Deputy Registrar at SIAC. His role primarily is to take care of the administration of all the cases filed with SIAC and supervision of SIAC's multinational secretariat. Kevin is a frequent speaker on contemporary issues in arbitration and conducts training sessions for arbitration stakeholders around the world. He's a member of Singapore Delegation at UNCITRAL Working Group 2 and represents SIAC as an observer at UNCITRAL Working Group 3 on ISDS. Over to you, Justice Sikri.
Thank you very much, Mr. Shashank, for your good afternoon to everybody, including my panelists. It's a pleasure to be here and sharing some of my views on the perspective of the tribunal insofar as complex construction arbitration disputes are concerned. Let me tell you that I have seen all three sides. I may begin with these remarks. From 1977 to 1999, as a lawyer, I had been doing cases and had done a lot of construction matters. Then 1999 to 2019, when I retired, in these 20 years as a judge of the High Court as well as a judge of the Supreme Court, I had been looking into the awards which were passed by the arbitrators and examining the validity of those awards, either as a judge of the original side of the High Court or as an appellate judge in the High Court or in the Supreme Court. And now for last 2 years, I have been now working as an arbitrator. And of course, 2 years is not a very long period, but I can tell you only this much, that in these 2 years, I've already given more than 25 awards. And so some experience as an arbitrator, at least in terms of work, I have gone through and have undertaken. And the perception in each of the category has been different. Of course, as a lawyer, when you argue the case, any particular case, you are arguing on behalf of your client, and therefore the emphasis is on the interest which you want to subserve as far as your client is concerned. As a judge, you are more looking into the justice aspects, and when you are undertaking a judicial review of an award, although in a very limited capacity, but then you see whether justice is done in the matter and not, and so the perspective is different. And as an arbitrator, you are the person as an arbitral tribunal in the first instance when you are sitting and you are resolving these disputes. So this varied experience has taught me something, and and in particularly in last 2 years, as I said, that insofar as the arbitration work I have been doing. But one thing which I have observed, and which all of you must have been told in this webinar, which has been going, this training program which has been going on, that most of the cases, the bulk of the cases today relate to construction arbitrations. And even I think the cases which I am having, arbitration cases, maybe 60% thereof would relate to construction arbitrations. As construction disputes are there, and therefore leading to construction arbitration. And what happens is that, which is fundamental in any arbitration proceedings, and which has been recognized throughout the world, and it's an ADR process which is away from the purpose is to have somebody with some expertise autonomy of the parties, confidentiality, etc. Apart from all those, the two major objectives which are there, that there should be an early resolution, a speedy resolution of the disputes, and it should be cost effective also. So it should not lead to incurring of high cost. And many arbitration reforms which have taken place throughout the world, and many arbitral institutions who are also working on this, including SIAC, etc. They aim at achieving these objectives. And so, therefore, although it applies to all kinds of arbitrations, but when it comes to the category of construction arbitration, it is something which is different to some extent. Of course, these are also arbitrations, but to some extent these are different. And as one of the very renowned arbitrator has said, that and he explains like this, that it is a separate breed of animals. So there are certain reasons for saying so. In the first instance, let us keep in mind that as far as infrastructure or construction is concerned, and it is the hallmark of advancement of civilization. And therefore, infrastructure activities, construction activities will keep on taking place, and that is a, universal phenomena. And as it is also said, that good infrastructure in any country is an indicator of prosperity. So therefore, construction sector occupies a very prominent place when it in any country, and India is no exception. And in such cases, when the disputes arise, construction dispute arise, it becomes all the more important to ensure that they are resolved as soon as possible. If you know, in India today, construction company is construction industry, I would say, is ailing because of so many reasons. And one of the reasons, if I may say so, apart from other reasons, is that the disputes are not resolved sooner. And failure of the parties to resolve disputes effectively and expeditiously is also causing this problem. So, and there may be various issues, we are not going into that. But what I'm saying is, now from tribunal's perspective, when I come to the topic at hand, that every tribunal or the arbitrator has to keep in mind these fundamentals at the back and the back in the at the back of our mind, and therefore try to resolve the disputes as soon as possible. And in this sense, the first thing which comes to my mind is the effective management of the complex construction arbitrations, which is very, very necessary for any arbitral tribunal. Of course, when it comes to institutional arbitration, suppose it is under SIAC, then the SIAC rules are there which govern how the process should go on. But then at the same time, it gives some kind of, I would say, latitude or freedom to the arbitral tribunal as well as parties also, insofar as the management of these disputes is concerned, of course, within the framework of the broad rules of any such institution. So therefore, what I feel is that in the beginning itself, in such cases, the terms of reference need to be settled between the parties, and it not only gives a glimpse of what the case is, summary of the claims and the counter claims, etc., and the arbitral tribunal gets a grip of that, and immediately followed there after has to be the CMC, that is what we call case management conference, and which would need is the expedition must be balanced with the need to allow each party to sufficient time as well, in accordance, in accord with principles of natural justice. So therefore, the that is the need of the hour that has to be done. Why I am emphasizing this point is that I have seen my limited experience as far as international arbitrations are concerned. I am into such at least 8 to 10 international arbitrations. I am doing at present 2 or 3 have finished also. But in domestic arbitration, when I feel that these CMCs and TORs are not given that kind of importance which is given in international arbitration, and therefore international arbitration, because of the rules of institutions also, they progress more smoothly. And we in domestic arbitration go little, I would say, not that the things are changing, but on ad hoc basis we proceed in a case, which should not be when it comes to the construction arbitration. And some of the aspects which need to be mind after the CMC, etc., and the timelines are drawn, how we have to proceed till the end, and pre-hearing conference, etc., also are needed. But one thing more which I have seen, and which is the expression which is called, used in England in English courts, is this is what is called that Scott schedules. Scott schedules is that, you see, when there are so many claims of different nature, and I'll come to those some of these aspects, because at present I am talking of the management, how to manage the and how to structure the arbitration proceedings. These Scott schedules are a form of a schedule where each claim, individual issue, is discussed separately, and therefore you are actually, fortunately, if I may say so, in one of the cases, of course, domestic arbitration, when where both parties are Indian parties, and it was the earlier arbitral tribunal was disbanded because of some reason with judicial intervention, and new tribunal was constituted, where I became the presiding arbitrator of that tribunal. And what I found was that, and we had to go by the record which was already there, that this Scott schedule was followed, and it we reserved the award few days ago, and I found that it becomes really handy, and it gives a lot of it facilitates understanding of the issues, different issues, in a different manner. So this is what I feel in because the time is only 30 minutes, and therefore I want to rush up all the things, that the first thing from the perspective of the tribunal is the proper and effective management, in order to ensure that timelines are there, and the arbitral tribunal is able to decide or dispose of or resolve these disputes as early as possible. Now, coming to, I tell you the specifics of such construction disputes. Let me tell you that there are few challenges in the construction arbitrations or construction disputes, which may not be in other kinds of arbitrations, and that is why it is called, as I said, separate breed of animals. It is this, that what is observed is that how well drafted the construction contract is. And it may be when at the time of drafting, best of the legal brains, and even say technical brains also, because in construction contract is the engineering aspects are involved, they apply their brains, and but it cannot be treated as when it comes to real at ground level, and when the disputes start, it is always found that such a contract had some of its shortcomings, and it was not complete, so to say, in inverted commas, in all respects. And these difficulties, the reason is that there may be so many contingencies which may arise at the time of execution of such construction contracts, which might not have been envisaged. And so therefore we cannot say that every contract is a foolproof contract. And in such circumstances, the challenge which is for the parties as well as the arbitral tribunal is how to interpret, and what kind of interpretation is to be given to various clauses to meet those contingencies which were either not explicitly mentioned there, or were impliedly, we can say that, arise. So thing is that the methodology which has been adopted is that we have to go by the contextual interpretation to know the intent of the parties, whenever such a situation arises. Of course, many times, many such terms which are used in the construction contract are already interpreted judicially by the judgments of the court. So those judicial interpretations of the contractual terms can be applied by the arbitrator. Then there are what we say, we find sometimes some implied rights and obligations, again judicially imposed by judicial judgments. It has happened from time to time, and I'll give one or two instances when I come to specifics. So that is another, that becomes another tool for the arbitral tribunal. And of course, along with that goes industry practice, which becomes very, very important, economic and industry realities. And based on that, what is the industry practice in the absence of any specific provision in the contract which was entered into by the parties. And another thing which has been seen, and as I said, with my limited experience, I have seen is that normally, because in many arbitral construction cases, when the parties appear, along with them the technical persons or engineers are also appearing on both sides. They are assisting their counsel, and one can find out from there that certain situations, lawyers and judges, they perceive it from different angle because they are legalistic and more into, but on the engineers or the technical persons, they have a different take on that. And therefore many times the outcome is of such cases I have seen is different when the lawyers or judges are the arbitrators, or on the other hand when technical person like engineers are the arbitrators, because therefore that again becomes a challenge in that sense. So these are some of the challenges, and how to meet that is the, as I said, there are some tools which I have already mentioned and which should be applied by the arbitral tribunal while deciding the cases. Now, what becomes important in these cases is that one thing which is seen, and that is very peculiar, and that gives rise to the further problems, or rather I won't say problem, further issues and disputes between the parties, and on the basis of which claims and counterclaims are filed by the parties. That is the delay. I mean, in any contract, any construction contract, the contract may specify the stipulate the period within which the contract is to be completed. It in no uncertain terms. I've seen all contracts, they say right from the letter of award, when the contract is executed, what is the commencement date, how much is the period, whether it is 36 months, 48 months, 40 months, or 18 months, depending upon the nature of the construction work, and what is the completion date. And it is also said normally in such cases, and particularly where the employer, as I've seen in domestic arbitration, is the government of India or the public sector undertaking, that the time is the essence of the contract, which I have seen even in those cases which I have come across where both the parties are the private parties, where the contract is awarded by a private party to the other party and not necessarily the government. So the time is specified. Many times it is stated that time is the essence of the contract. And in any construction contract, there are certain obligations which are to be performed by both the so when it comes to the employer, of course, then when which wants construction to be done of whatever nature, it may be a railway construction of a bridge, it may be some road which is constructed, or it may be building which is under construction. So all these kind, for all that, one needs some site for that. So this site is to be provided by the employer on which the construction is to take place. And in case of roads, etc., and railway bridges, etc., it's a right of way, which is because it is not limited to some area. It may go into kilometers of the area. Of course, a specified area of, say, if it is a road, whether it is 50 meters or 40 meters or 30 meters, and going into 40 kilometers, 50 kilometers, 100 kilometers, depending on the nature of the contract. But that right of way is to be provided by. Then the construction drawings, because it is the employer who wants what kind of drawings are to be given. So what kind of construction is to be made. So the construction drawings are provided by. So we have seen normally along with the when the tenders are invited and bids are invited, tenders is floated and bids are invited. Along with them, along with that, some drawings are there, but they are indicative of what is going to be. And it is always stated in such contracts that good for construction drawing, or GFC, what we call, would be given, and that may be depend when the actual work is to be done. Because the earlier drawings which are given are indicative on the basis of which the bidder can make its bid. So these may be some of the conditions, precedents which are to be, or obligation which are to be performed by the employer. Likewise, the contractor has also to perform certain obligation before the start of the work. It may be normally what happens, performance guarantee which is to be given, and many times when mobilization advance is given by the employer, the guarantee for that mobilization advance and how it will be offset during the execution. So that is to be done by the contractor. Then mobilization of the resources at site, for which normally mobilization period is given, and which may include mobilize that site office, then some rest house, etc., depending upon the nature of the contract. So those kinds of things are also there, which would become the obligation of the contractor. So these are the conditions precedents. What happens that many times, as I was coming to delays, when the contract is not completed within the specified period, for which both the parties blame each other. As far as the contractor is concerned, it says that, look, I was not given right of way or the clear site. As in India, there are many times the encroachment on the sites, etc. So it was not clear site, or many times from the other public authorities, some permissions are to be taken. Suppose the road is going through jungle, and forest department's permission is to be taken. Or even if it is within this city, then permission of municipal corporation is to be taken, or environment clearance is to be taken in some cases. So such clearances are, etc. It is the obligation of the employer to take it. So the contractor may come out with it, look, these approvals were not coming in time, which led to delays. Drawings were not given in time, which led to delays. So delays can be attributed to the employer. And on the other hand, normally the employer comes with the plea that, look, although I had done my work, but the required plant and machinery or the labor was not mobilized by the contractor. So work was going at a slow pace, and therefore it was not carried out. Many times contractor also come out with the plea that my running account bills, which was submitted from time to time, there was delay or the payments were withheld unnecessarily. So it is seen that it doesn't finish in time. So then the legal issues which arise is, first, of course, there is always a provision for extension of time. There are force majeure clauses also. The delay may happen because of neither attributed to the employer nor attributed to the contractor, but force majeure conditions. So in such cases, there is always normally clause relating to extension of time, which can be given under such circumstances. So extension of time clauses normally say with or without liquidated damages. There may be a clause for imposition of liquidated damages if the delay is on the part of the contractor. And such extensions are given by the employer. At that time, either it is with LD or it is stated that, no, okay, we are not imposing, but we reserve our right to impose LD at a later stage. Now, the issues which arise when the contract gets delayed because of this reason. Now, the the contractor, he says that, look, the contract which was to be, or the work which was to be completed in 3 years, it took 6 years time. and therefore my cost escalated. So I should be compensated for that. The rates at which I quoted, it may be item rate contract, BOQ, which we call, or it may be a lump sum contract. It says that my cost escalated, I should be paid higher. If it was item rate contract, the contractor may say that, look, the rates increase in the meantime, and so therefore I have to be paid more. And lump sum contract, and same thing, because of that my cost has escalated. And many times, because of the, suppose the contractor says that I had mobilized my resources, but they were sitting idle, either plant and machinery or the labor, and therefore idling cost, the claim of idling cost are made, and the claims for even overhead expenses are made, and ultimately, apart from compensation, claim for damages or loss of profits, etc., which are made. So these kinds of claims which are made, on the basis of which, of course, these are to be decided on the basis of evidence that is produced. But I will only say, let me see how much time I have, and during maybe in next 5 or 7 minutes, I'll only try to say what kind of issues which become very, very important issues, legal issues which arise and which have to be decided. Now, first thing which becomes important in such cases, and on that basis, the law or the provisions of Indian Contract Act, etc., would have to be applied, whether the time was essence of the contract or not. So if the time did not remain the essence of the contract, then the contractor makes its claims on that basis. Of course, if contractor has suffered some losses, then we have the provision in the form of Section 73 and 74 of the Contract Act, which talks of the damages for breach of contract. And if the condition precedent or other obligations were not fulfilled by the employer, or vice versa, then and the loss is suffered because of that, then under Section 73 or 74, as the case may be, the claim can be preferred. And but then when time is essence, the Section 55 of the Contract Act comes into play, which says that if it is not fulfilled within the time and there is a breach on the other side, then the person, like here in this, if we say that there is a breach on the part of the employer, the contract has right to terminate the contract. But then Section 55 also says that it can exercise its discretion not to terminate, but go ahead with the work, and can at the same time say that I will be entitled to the damages or compensation because of this delay. And for that, it has to give notice to the employer. And for that reason, the first question, whether time is essence of the contract or not, that becomes important. And I have seen in most of the cases, it is argued whether the time was essence of the contract or not. There are various judgments of that, and time doesn't permit. If in panel discussion questions arise, and we will discuss on that. But let me say that in a sense, the principle is that the Supreme Court of India has said in so many cases, wherever normally, where in number one, in construction cases, normally, if there is no specific clause, time will not be essence of the contract. And number two, even if there is a clause that time is the essence of the contract, but then there are clauses for extension of time, then also time doesn't remain the essence of the contract. But at the same time, there are certain judgments which say, even if in those cases the extension can be given, but extension is again given for a specified time by the employer, stating that this extension we are giving for this season, force majeure or whatever, and therefore this is now time would remain the essence of the contract. Now time is extended but made essence of the contract again, then it can be treated as time as essence of the contract. That is in nutshell the law on this. But what is more important is, normally in such cases, when the contract proceeds even after the stipulation date, under Section 55, what the arbitral tribunal is supposed to see, whether any notice was given that we will be by the contractor to the employer, that I'm reserving my rights to claim damages or escalation in cost, etc. And the things would depend upon that. Another thing which is very interesting, which we have found in these cases, is that although there, if the delay is on the part of the employee, or sorry, the contractor, clause says that for delay of each week or each month, X percentage of the contract value would be taken as damages, which is liquidated damages, predetermined damages, subject to a cap of 5% or 10% of the contract value. But then, on the other hand, it is said that if the delay is because the delay has occurred because of the employer will give suitable extension of time, but the contractor will not be entitled to any compensation. So this is what we call exclusionary clauses, that they exclude the contractor from claiming any damages. So such clauses have come before the court for interpretation, and there's a lots and lots of judgments on that. But interestingly, as I mean, scanned through all these judgment, and I'm not at this stage again, as I said, mentioning those judgments. But what can be said, the outcome is that, look, where the delay is unreasonable, in spite of these clauses, you cannot deprive a person from claiming the compensation or damages because it has suffered loss because of that. And it may be on the principle of what we call disruption delays, which is used, this is the expression used by American courts, and in those that the disruption delays have taken place, so compensation has to be given. And other thing is that some of the judgments of Indian courts have said, look, if this clause is there, it may be for the department. So department may not give, but it is not binding on the arbitrator or the courts. So courts can still grant, because law, section 73, 74, they permit that the compensation can be given, and therefore you cannot, deprive a contractor from taking the compensation, and the arbitrator is within its power to do so. But another interesting thing which arises in the such construction contract is that there, and real, practical things which are seen, and the realities of the situations are that there may be delays on both sides, and this becomes a challenge for the arbitrators. So delays may be on both sides, then, and the delays may be of various natures. So what is important is, and the law which is laid down, that it's not minor delays, etc., which have to for which we have to bother, and which may not have any effect on the completion of the contract. It should be the critical delays. The expression uses critical delays which had impacted the execution of the contract. And there it is called, it may be another nomenclature which is given is that, sorry, before that I come to the question is, that is one aspect. But then the second aspect is that, as I said, the delays may be on both sides. So how much delay can be attributed to the employer? How much delay can be attributed? Suppose the total delay in the completion of the contract, or that construction contract was, say, 3 years. So out of these 3 years, how much is attributed to the employer and how much is attributed to the contractor? This delay analysis has to take place, for which normally in many departments I've seen this exercise is undertaken, particularly while deciding whether the liquidated damages are to be imposed or not. But many times the expert evidence is brought before the arbitrators also. But in few cases I have found that no evidence is brought of any nature whatsoever, and it is the tribunal which is to go into this exercise, and it becomes a difficult exercise to be done, because of the lack of data, etc., and lack of expertise also. It is very difficult. But then the question that arises is, and here the I would say jurisprudence which has been developed is whether these delays were concurrent delays, or whether these delays or the parallel delays, or whether these delays are the causes which can be attributed to the employer, whether they are dominant causes, or in contrast, whether they are material causes. if there are dominant causes attributed to one party, then the delay during that period of other will not have any impact at all, because suppose the for construction of the building, drawings are not given. Now, even if there is some delay in mobilization of the resources by the contractor, may not be of any consequence, because even if the resources were mobilized, in the absence of drawings, the contractor could not have started the work. So that is a dominant cause. It becomes there are situations where, as I said, the delays can be attributed to both the parties, and depending upon that, how much damages, etc., are to be given, it has to be decided. Another interesting issues which have arisen in certain circumstances and which has to be seen is what kind of evidence is to be led in order to prove the damages, which becomes very, very important, and it depends on different kinds of claims which are made. If it is idling and of resources, then whether because why I'm saying so, many times the documents are filed that this was our labor, this was the supervisory of staff which was there, this was the managerial staff which was assigned to that, we had paid them all these salary and wages, those registers are produced, and likewise list of machinery and plant which was there at site is produced. Many others, they don't produce any such kind of evidence, and they say that, look, go by this, that Hudson formula or other formula, that look, this 10% should be is treated as normally the labor component. So therefore, the total work was this, and 10% of that is the labor cost, and 2 months delay. So for 2 months, I should be paid proportionately like this. Such a kind of evidence is also led sometime for loss of profits, as I said, if it 10%, 15%, and there are judgments. But they raise very tricky issues sometimes in real practice because of loss. I don't have that much time that I can dilate on that and discuss those intricacies. But what I'm trying to say is that from the perspective of tribunal, and in my half an hour time, which I could say that these are some of the thorny issues which arise, which we have to decide. Thank you very much.
Thank you very much, sir. Those were some very interesting tips and insight for all the practitioners. I'm sure everybody is benefited, not only the in-house counsels, the prospective arbitrators would also make use of these points to understand complex construction disputes. Now I would request Kevin to discuss the arbitral institutions perspective.
Thank you, Shashank. And let me start with a few observations. I guess the first would be the impossibility of following Justice Sikri. I was trying to decide if it was better to go before or after, so I know that this is impossible. So this is a challenge for me, and also how useful the interventions of all of the panelists have been. I think it shows the institution is always listening, because I have 6 pages of notes, and this is particularly relevant as we are in the process of a rules revision. So we've heard the Indian perspective, the international perspective, and then the perspective from the tribunal. Now let us see what the institution can offer. Because this is framed as a master class, what I'm going to try to do is give everyone really a peek behind the veil. We all know these institutional rules and provisions, but how do they really work in practice? I will say as a cautionary point that all of the views that I will express today are my own and don't necessarily represent the views of the institution and don't indicate how we might decide on a procedural issue. I say that so we can speak freely and hopefully give substantive replies to some of the tricky questions that we deal with when we're administering construction disputes. Let me try to set the framework by giving a brief background on SIC's experience with Indian parties and then construction disputes overall. As many of you would have heard, in November of 2020, the Minister of Law of Singapore indicated that SIC had received more than 1,000 disputes. So this is the most disputes that we've ever received. Almost all of these are international. More encouraging from an Indian arbitration standpoint is in 2019, nearly 500 Indian parties chose to bring their disputes to SIC. This is more than any other jurisdiction on the docket. And part of this is what we're seeing is a move from Indian parties towards institutional arbitration. And I will discuss this a bit at the drafting stage, because that's one of the fundamental and threshold questions when you're drafting an arbitration clause, particularly in relation, say, to a major project. Do you want institutional arbitration or ad hoc arbitration? Now, at SIC, because we have so many Indian parties, we've really tried to design our rules and procedures and our overall structure to be able to cater to Indian parties. So we have an Indian member of the board of directors, 4 Indian members of the SIC Court of Arbitration. We have 2 SIC counsel who are qualified in India. And then, of course, we have Justice Sikri, Mohan, and many Indian arbitrators on the SIC panel of arbitrators. And this is important because what we're seeing is we're seeing more and more Indian parties choosing, for instance, a seat in Mumbai or Delhi. Or it could be back when we were having physical hearings, the parties were choosing to have the venue of the arbitration in India. Leaving aside whether 2 Indian parties can choose a foreign seat, we hope that will be dealt with fairly soon. So we have Indian parties choosing Indian seats, but then many Indian parties choosing Singapore seats. And this has important consequences. In terms of our construction portfolio in 2019, 1 out of every 6 cases submitted to SIC involved construction, engineering, major projects. Again, most of these international, but there is a robust construction framework in Singapore, so also domestic Singapore disputes. The sums at issue in these cases would range from, say, USD 100,000 to in excess of USD 5 billion. What we're noticing at SIC is even the smaller value construction disputes are becoming more and more complex. As many of you would know, we perform the scrutiny or review of the award, and it's now not unusual to see an award in a complex construction dispute that might span 500 pages or 700 pages, involve parties from many jurisdictions, witnesses of fact, expert witnesses, counsel from all over the globe. And then we have to deal with all of that in the context of COVID-19, where most of the hearings are virtual hearings, are hybrid hearings. So the experience of an institution is important, and particularly in the context of construction disputes, because it does take a high degree of nuance. So, and we've received, of course, very good advice from our panelists on drafting arbitration clauses, but I will give the institutional perspective on drafting arbitration clauses, what you want to put in there, what you want to look out for. And then the second broad point is SIC's case management techniques for helping to control time and costs, particularly in complex construction cases. So let's start with drafting the arbitration clause. And perhaps to be a bit provocative, I will say that you could draft a perfectly valid arbitration clause with 3 words. So you could say arbitration, period, Singapore, period, SIC, period. And then the argument is arbitration, maybe it's just 1 word, but that might be a mandatory reference to arbitration. Singapore, the seat of arbitration, and then SIC, the administering institution. Now, you would never advise anyone to draft a 3-word arbitration clause. But I think sometimes where the difficulties arise is when parties are being overly prescriptive. Having seen thousands and thousands of arbitration clauses, I get concerned as soon as I see an arbitration clause that is longer than 1 page. We will see arbitration clauses that might be 3 pages. And as you look through that clause, it is only a matter of time before there's a contradiction within the clause. So I think that you want to be very careful and make sure that you're getting advice on the drafting of an arbitration clause. The starting point, as I mentioned, is ad hoc versus institutional arbitration. And there are very good reasons for both. There's a robust, very rich tradition in India of using ad hoc arbitration, also in Singapore using ad hoc arbitration, and there are certain disputes that will work very well in the ad hoc framework. This is when you have, say, very sophisticated counsel that know how to customize the procedure, a senior eminent tribunal. In those cases, ad hoc arbitration is very good. Where institutional arbitration can be a bit more valuable is to help move proceedings along and have an institution there for oversight when things might go a bit sideways. And this can be particularly the case in construction arbitration. This could be a very complex dispute. We have seen disputes with variation orders, more than 2,000 variation orders. You might have a non-participating respondent or an intermittently participating respondent, and then not to mention many of the procedural features. So some of the features that I'm going to talk about today, emergency arbitration, early dismissal, consolidation, joinder, the parties can contract for some of these, but most of these provisions are going to be available in all the sets of institutional rules, not just the SIC rules, but many sets of institutional rules. One way to think about incorporating institutional rules is it really takes a lot of pressure out of drafting a contract. Now, there's nothing wrong with drafting a bespoke contract and customizing certain provisions on joinder, consolidation, appointment. But if you don't want to do that, you can just take the institutional model clause that every institution has available, which then incorporates all of these different procedural mechanisms. So ad hoc versus institutional arbitration, the first big choice at the transaction stage. Then you want to think about the seat and the applicable law. The seat of arbitration, that's really the home of the arbitration. So if you choose an Indian seat, then the curial court will be the Indian courts. If you choose a Singapore seat and you need intervention in assistance of the arbitration, then you'll be going to the Singapore court. Of course, depending on, say, if it's a domestic arbitration in India, of course, you're going to have timelines to be cognizant of. And so the considerations for either an Indian seat or a Singapore seat, you really need to be alive to that. Number of arbitrators, important. I mean, typically in these kind of disputes, parties are going to want a 3-member tribunal, each side nominating one arbitrator. The institutional default at SIC is that the institution then appoints the presiding arbitrator. Many times parties will nominate the presiding arbitrator, the parties to nominate the presiding arbitrator, as is in the position in Singapore arbitration. So you need to be cognizant of that. Particularly with multi-party disputes, virtually every institution has a rule that's effectively called the DUTCO rule. And this is if you have multiple claimants and multiple respondents. Unless both sides jointly nominate an arbitrator, then the institution will appoint all 3 arbitrators. And this is important. So if you have multiple claimants and multiple respondents, perhaps the respondents are adverse to each other. It could be down the string of contractor, subcontractor as respondents. If they're adverse to each other and they're unable to come up with a joint nomination, even if the claimant has nominated an arbitrator, it may well be the case that the institution is going to appoint all 3 arbitrators. Also, you want to be mindful and aware of the fact that if you have an application for consolidation or joinder, which will often be the case in these construction disputes, the timeline for the appointment of arbitrators is going to spring and joinder. Now, there's a very good reason why we do that, because if you're bringing in a new party or you're collapsing a bunch of parties and disputes into one dispute, you want all of those parties to be able to participate in the constitution of the tribunal. Parties should also, and Mohan and Weijin have explained this quite well, but the multi-tiered clauses, step clauses, we see that a lot in construction disputes. So whether there's reference to a dispute board, this may not be circumvented, or it could be mediation, then arbitration, a period of negotiation. As some of the other panelists have said, you want to make sure that those terms are very clear. The way that I look at it in certain instances, particularly with a precondition for negotiation, parties should be negotiating in any event. Anytime you're drafting an arbitration clause, you want to be mindful of the fact that this dispute may be 5 years from now. So you want to make sure that you know what the color and complexity of the dispute is going to be at that stage. The position in Singapore following is that if you contract for clear steps prior to the commencement of arbitration, you are likely going to be bound to those steps. A brief comment on the language of the arbitration. This is something that we would always recommend that parties specify. From time to time, we will see parties who want a dual language arbitration. That can create some issues. It's likely going to require 2 awards. The bespoke customized clauses that I was talking about, certainly we see this a lot. I think one of my favorite customized clauses, and this ended up being a post-commencement variation, is when on the appointment of arbitrators, the parties finally agreed to settle the appointment of arbitrators by a coin flip. More practically, for construction disputes, you might want to have an arbitration clause that limits the amount of pre-hearing discovery, like I said, provides for joinder and consolidation, juxtaposing and being cognizant of the fact that joinder and consolidation is in the institutional rules. And then right now, virtual hearings. Maybe you want to make clear or you want to avoid specifying the venue of arbitration. It's somewhat of an unanswered question, and we certainly see this in a lot of student moots right now, is if the venue is specified, say, as Mumbai or Singapore, does that mean that a virtual hearing can still take place? Our view, and I think the general view, is that it's not going to prevent a virtual hearing, particularly in the context of SIC, where the tribunal has broad discretion and there is reference to video conferencing, but you want to be a bit mindful of that, of whether you want to prescriptively set out considerations on venue. Qualifications of arbitrators, this is important in construction disputes, but you don't want to be too specific with the qualifications of the arbitrators. We've had a few cases where I am still looking around the world for any person on earth that would have fulfilled the qualifications of the arbitrator that was ensconced in the clause. One very useful technique that the parties can use is to make proposals. So these are not agreed qualifications within the clause, but it's the claimant saying that we think that the arbitrator should have 30 years of experience in construction disputes, be qualified in Singapore, as the case may be. The respondent, on the opposite token, might make its own proposals. The institution will always try to give effect to proposals. We are not bound by them, but you want to be a bit careful on very specific qualifications. We sometimes see asymmetric clauses that can bring issues of natural justice where, say, for instance, one side gets to appoint all three arbitrators. We're still seeing quite a few clauses where it's a two-member tribunal, and if those two arbitrators are not able to agree, then an umpire will be appointed to decide. Make sure that you know that an umpire is different than an arbitrator. So if you want a three-member tribunal, a two-member tribunal with an umpire is different, and the umpire is there when the co-arbitrators disagree. Now, I say all of this because ultimately what all of us are looking for is for these construction disputes to run more quickly and more cost effectively. What's going to happen with a loosely drafted arbitration clause is that then there is going to end up being a jurisdictional phase. It might start with the institution where an application will be made to the SIC court for a prima facie decision on jurisdiction. The proceedings may then be bifurcated or trifurcated or have 4 phases where jurisdiction is going to take up a lot of time. And you can cure a lot of this by a well-drafted arbitration clause. On that point, I would like to take Mohan's suggestion that bifurcation sometimes will be a tactic used by parties to try to prolong the proceedings. So in the right circumstances, bifurcation, trifurcation, or bifurcation, particularly in the context of a good faith jurisdictional objection, can be effective. If jurisdiction can be dealt with as a preliminary question, it's not intertwined in the merits, it can be helpful to have that dealt with in the first instance as the first phase. Other times parties will use it where they're trying to protract the arbitration proceedings. So depending on the case, really horses for courses. On the appointment of arbitrators, like I was saying, from the institutional standpoint, when you're selecting an institution, see what all of their appointment mechanisms are and who makes the appointment. So SIC has made thousands of appointments, and we've made many of these appointments in construction disputes. Where I get concerned is anytime an appointment is being made without background or experience on the particular arbitrator. The reason why the SIC appointment regime is quite effective is because we have the scrutiny of the awards and very structured administration. So we review all of the awards of the tribunal, we really monitor the progress of the case, and on that basis, then we are able to appoint arbitrators based on SIC's experience with these arbitrators. Just some brief observations on some of the case management techniques, and this is really just from the institution as an observer that tribunals can use that we found to be effective. The tribunal, of course, is the master of the arbitral proceedings. That case management conference and setting the procedural schedule at an early stage is important. Anytime the tribunals can get an agreed list of issues, that contributes to the efficiency of the proceedings and then the eventual enforceability. it is very easy to deal with all the issues when the parties have agreed to that list of issues. And sometimes we've seen certain cases where the parties will actually come to the realization that there's not that much in dispute. So you could have a case where there's 50 heads of claim, 100 heads of claim, but really there's just a few where the parties are at odds, and perhaps some of those could go to mediation. So we've seen that sometimes deployed in the arbitration. Some of the claims where the parties are a bit closer together could go to mediation. Tribunals and parties also often will adopt various soft laws. So it might be the IBA guidelines of the taking of evidence. So getting that first CMC early in the proceedings, trying to get an agreed list of issues where possible can be effective. What we've seen during COVID-19 in terms of some of the procedural mechanisms, we've seen a lot of applications for the appointment of an emergency arbitrator. Most of you would be familiar with how this provision works. It's prior to the constitution of the tribunal. Instead of going to court, and as Weejan explained, you still can go to court, you can make the application for the appointment of an emergency arbitrator. This is a very effective tool. As was mentioned, and one of the most common requests for relief that we see is restraining a call on, say, on a performance bond. So it might be Friday, application for the appointment of an emergency arbitrator. The call on the bond is on Monday. As most of you would be familiar with these provisions, let me run you through a few case studies. In a few instances, I've had to aggregate the data, change the names, change a few things, but just to give you an idea of how these provisions work, particularly in the India context. So the first example that we have is a sale and purchase agreement that's related to a construction project. The arbitration agreement included a clause that referred to the SIC rules 2016. So the respondents going outside of the arbitration agreement initiated court proceedings in India. The claimant commenced SIC arbitration with the notice of arbitration. 3 weeks after the notice of arbitration, which is a bit irregular, the claimant then applied for emergency interim relief. Because you had this parallel court proceeding, the claimant's application for emergency interim relief prayed for a declaration that all the disputes fell within the arbitration agreement, that the respondents' commencement of the court proceedings breached the arbitration agreement, and also requested a permanent final injunction directing the respondents to withdraw or discontinue the court proceedings. The SIC president accepted the application, and an emergency arbitrator was appointed in less than 24 hours. The result was the emergency arbitrator's issue was issued within 14 days from the date of the EA appointment. The relief was granted to order the respondents to withdraw and discontinue the court proceedings. From SIC's administrative standpoint, we were able to complete the scrutiny. This is the review of the award in less than 3 hours. And what was good about this case is there was voluntary compliance by the respondent. So the claimant, the applicant, didn't have to take this emergency arbitrator order to court to try to give effect to the emergency arbitrator's order. So the parties, and then following the voluntary compliance by the respondent, the parties eventually reached a settlement and a consent award was issued. The next emergency arbitrator case study that we have was a matter that we had with an Indian main contractor, and the respondent was an Indian employer. The seat of arbitration in this case was Singapore, and the substantive law with two Indian parties was Indian law. As part of the contract, the respondent had engaged the claimant as the main contractor for a construction project. The claimant provided 3 bank guarantees to the respondent. Disputes then arose between the parties as to whether the works under the contracts were completed, and the claimant commenced arbitration and sought an injunction from an emergency arbitrator to restrain the respondent from calling on the bank guarantees. What's useful about the SIC provisions is it is expressly codified. The emergency arbitrator may make preliminary orders, and in this case, the claimant applied for and got 2 preliminary orders from the emergency arbitrator pending the hearing of the application, directing the claimant to extend the validity of the bank guarantees and restraining the respondent from calling on the guarantees. Notwithstanding that, and in any event, the respondent did go ahead and call on the bank guarantees. What happened at the hearing was then quite interesting, because the respondent made the argument that given that the bank guarantees had already been encashed, there was nothing for the emergency arbitrator to decide, and the emergency arbitrator was ineffective and not needed in this circumstance. So what the emergency arbitrator did in this case, in addition to applying the transnational test, found that the respondent by its conduct had to a large degree validated the claimant's need for the application of interim measures. The fact that there was these preliminary orders and then the respondent went and called on the bank guarantees in any event. Emergency arbitration, I guess to close it off, something that Indian parties are very familiar with, that we have a lot of experience on this in Singapore, and something that parties should be aware of as an option prior to the constitution of the tribunal. Sometimes when we're explaining these emergency arbitrator provisions, what we like to say is that most of these are status quo injunctions, prohibitory injunctions, keep everything the same. From time to time, there will be mandatory injunctions where the emergency arbitrator is telling the parties to do something, but also be aware that this is all subject to variation, discharge by the tribunal. From the Indian standpoint, as many of you would be aware, that some of the world's most seminal decisions on emergency arbitration are emanating from SIC and India. So there are a quartet of cases now, some under Section 9 ultimately, some under Section 17. We'll see how these move along. But really, arbitration is looking at all of these decisions, and they're really a great support of the emergency arbitrator procedure. Let's look at multiple contracts, consolidation, and joinder for a few minutes, because this is going to arise in many construction disputes. There are many layers of contracts and subcontracts within a project, and on even a medium-sized project, there will be subcontractors, suppliers. There might be a separate side contract with a designer. So it is a complex contractual matrix. The advantage that the SIC consolidation provisions have is that you don't require identity of the parties. We think that this is the part of the reason why SIC is getting a lot of these big ticket construction disputes, because many of these cases will involve different parties. There is a two-stage test for the application for consolidation, and there's some tactical reasons why you might want to do it either way. So you might want to consolidate prior to constitution, or say if it's a sole arbitrator tribunal, you might say in a case of a string of 5 contracts, you might want to have the same tribunal, the same sole arbitrator appointed in each of those arbitrations, and then make an application for consolidation thereafter. The reason why you might want to do that is it could be the case that the SIC court decides that 5 contracts between owner, contractor, subcontractor are all worthy of consolidation. But it could be the case the tribunal, who has ultimate charge of the jurisdiction, might find that one of those 5 cases, the tribunal doesn't have jurisdiction over this 5th contract. And then there's a question of what happens to that 5th contract. So if it was a sole arbitrator, for instance, you might want to get the same arbitrator appointed in each of those 5 cases, and then the tribunal could decide 4 of these can be consolidated, and then this 5th case will be run separately. So there's a variety of tactical considerations. I guess the takeaway for SIC's consolidation and joinder provisions, they are very broad. You don't need the parties to be a signatory to the contract in the case of joinder. Early dismissal is another provision that SIC has that has proven very popular, and particularly during COVID-19, where you have a lot of cases, including in construction cases, where there's non-performance, and then the respondent is not denying the non-performance and is just saying force majeure. The analysis then turns on the boundaries of the force majeure clause. So this just becomes a very simple legal question. So a party can apply for the early dismissal of both a claim or a defense. This is similar or familiar to all of us who are common law lawyers, similar to summary judgment or striking out. What has been very useful, I think, in the context of the SIC early dismissal procedure is the fact that we effectively updated and evolved the ICSID procedure under Rule 41.5. So you have all of this investment arbitration jurisprudence that is now being imported into commercial arbitration. But this can be a very effective tool to use both on the claimant side and the respondent side. I would say that most people would agree that tribunals have this power inherently. The reason why we wanted to codify it in the rules is effectively to give tribunals a bit more incentive to use it. And then the eventual enforcement court, when a tribunal exercises these powers, can then look at the provision and see that the tribunal is authorized to do so. So we can think of a lot of different circumstances, and certainly at SIC, we've seen a lot of different circumstances where these provisions have been used, and particularly in the context of compliance with a dispute board precondition. There could be an application from the respondent side and say if there wasn't compliance by the claimant for early dismissal on the basis of manifest lack of jurisdiction. And in this case, we'll look at jurisdiction and admissibility as two sides of the same coin. In the SIC investment arbitration rules, there's a specific provision on admissibility, but that is a way that a common way that early dismissal could be used in the context of a construction dispute. We have another interesting case that applies to any kind of dispute, and what was very unique about this, and there's been a bit of public commentary on this case, it was early dismissal in the context of an administrative defense. So typically early dismissal would be used on the substance. In this case, the early dismissal application made by the claimant against the respondent was on the basis that the respondent had not paid its share of the deposits towards the estimated cost of arbitration. This will happen very often in institutional arbitration, ad hoc arbitration as well. Only one side is paying the deposits. So the claimant making an application under Rule 27G of the SIC rules, they made an application for an award on unpaid costs. They also had a complementary application for early dismissal, saying there's no good defense to the respondent's case, which the respondent was trying to make, saying that they had financial difficulties and they could therefore not pay their share. The tribunal accepted the claimant's position. The parties are under an obligation to comply with the applicable institutional rules once they have agreed to those rules, and it was a straightforward contractual matter. And if the arbitrator party is in breach of the contract if it fails to pay those deposits. I see that my time is getting a bit short, and a lot of these we'll be able to deal with in the question and answer period. And I might close by a discussion on virtual hearings, because this has changed the way that arbitration is practiced overall. It's a change for counsel, for arbitrators, and for an institution. As I was saying at the outset, we are very lucky in Singapore because we have physical hearings that are now starting at a safe social distance. We also have hybrid hearings where you might have both sets of counsel, president in Singapore, presiding arbitrator in Singapore, and then the co-arbitrators dialing in. Our experience with this has been really, really successful. And what's been surprising and encouraging to me is that I never thought that there were going to be virtual hearings in these big ticket construction disputes. I accepted that it might be possible in the small value disputes, but these construction disputes where witness testimony is so critical, parties generally have been open to using these virtual mechanisms. SIC has also issued a guide called Taking Your Arbitration Remote. What we are often seeing is that you will have very experienced counsel and arbitrators, but sometimes they have not done too many virtual hearings. We'd certainly recommend that parties and tribunals look at the SIC guide just as a checklist before a virtual hearing. In terms of some of the challenges that we face and that all arbitration stakeholders have to be aware of, and I guess the first choice is a virtual hearing appropriate, a fully virtual hearing, depending on the circumstances of the case? How are the parties in the tribunal going to maintain confidentiality and data security? What are the due process concerns? How are we going to deal with potential technological disruptions? And what about the eventual enforceability of the award? So when you're considering whether or not there is going to be a virtual hearing, you want to look at the provisions under the institutional rules, the governing law of the contract, the law of the arbitration agreement, and the law of the seat, as well as any potential places of enforcement. There are, I suppose, three primary situations that arise when tribunals are deciding whether or not to proceed with a virtual hearing. It's when one party wants a virtual hearing and the other side objects. This has recently been dealt with by the Austrian Supreme Court. and where both parties would like to have a virtual hearing, but the tribunal wants a physical hearing, and then where both parties want a virtual hearing and the tribunal proceeds virtually. I suppose gathering what we've learned at SIC and looking at the recent judgments and all the academic commentary is that there is a duty to treat all parties fairly, including an obligation to ensure that both parties have a fair opportunity to participate in the hearing. But under the SIC rules, the tribunal has a very broad power to conduct the proceedings in the way that it finds appropriate. The Singapore Court of Appeal has also recently found that a full opportunity to present one's case under Article 18 of the model law is not unlimited. I think that what we're trying to encourage from SIC standpoint is the efficiencies of virtual hearings in certain cases. It will certainly help save time and costs. Case management, conferences, potentially a hearing on jurisdiction, these may be appropriate to be done in a virtual way. I guess 2 points in conclusion. The first is to think very carefully about the choice between ad hoc arbitration and institutional arbitration, particularly in the context of major projects. The second is to think about that impact on costs. Would you prefer to be within the institutional structure in terms of managing the time and costs? There is a very well-known study put forward by ICC that shows that 80% of the overall costs in an arbitration are from counsel, and it's a shade under 20% for the arbitrators and the institution. There is a direct relationship in how long an arbitration takes and how much it's going to cost. What I think that most institutions, or all institutions, when we're doing our jobs right, is that we can help make sure that these arbitrations are proceeding in a bit more of a speedy way. Thank you, Shashank. I will pass it back to you.
Thank you, Kevin. In fact, the last point that you made is very interesting because India at present is grappling with the issue of virtual to hybrid to completely physical and then coming back to hybrid. We'll see how this pans out in respect of arbitrations also, because currently everything is completely virtual with very, very few cases where tribunals are doing hybrid. But I think hybrid could be a format, at least in international arbitrations, which may stay even after full recovery from this COVID era. Possibly a gift of this pandemic to the arbitration ecosystem. We're very, very fortunate to have some of our speakers throughout the day to answer the questions that we have received in advance and during the course of the proceedings. May I welcome again Mr. Mohan Pillai from Pinson Mason M. Pillai, Mr. V. Gian Ang, partner Pinson Mason M. Pillai, Honorable Justice A.K. Sikri, Kevin Nash, and Mr. Atul Sharma, who has joined us in this final session. Before we proceed, I will very quickly introduce Mr. Atul Sharma. Mr. Sharma is the managing partner of Link Legal India Law Services. He comes with an experience of over 40 years of aviation and infrastructure law. He represents major corporate clients in various courts, international tribunals, and other judicial and quasi-judicial forums, providing advice on all aspects of civil commercial laws, including company, economic laws, antitrust laws, consumer protection, aviation law, etc. He's also the chair of Aviation Committee of Inter-Pacific Bar Association. We welcome you, Mr. Sharma, to the panel discussion. So to kickstart this panel discussion, I'll in fact begin with you, Mr. Sharma. My first question, slightly a broad question for, in fact, all the panelists to answer after you have spoken. This is on the basis of your experience in the last 1 year. Do you think we are now completely equipped to handle the post-COVID era when we are doing these complex infrastructure and construction disputes? What were the challenges that you faced in the last 1 year? What are the practice hacks that you can discuss with us that you have discovered? Discussing one of the gifts of the pandemic. Are there any more gifts that we are likely to continue with once we have completely recovered?
Thank you, Shashank, and thank you, organizers, for this opportunity. Having seen what we have seen in the last 1 year, I can say with some degree of confidence that so far as arbitration is concerned, barring the first 2 months, it has had the most smooth ride in terms of no delays. So the whole system has adopted so well to the virtual method. I did an arbitration where we had to do recording of an evidence as well as cross-examination. The witness was based in Bombay. He flew into Delhi. We arranged a room at Delhi airport so that he doesn't have the problem of coming out and getting quarantined. We did the cross-examination there. We had a local person sitting in that room to make sure that there is no prompting. This is the level to which the arbitrations have gone so far as this period is concerned. I don't think, and in fact, arbitrations have gained in the sense that large number of counsels who practice both in the courts as well as tribunals were available in their houses or in their offices. So they had that time, and arbitration, the best thing about arbitration is that once you are in a room, you have no other case to attend, unlike a court where you have a list running and you are scampering from one courtroom to the other. And then, of course, it is dependent on how the list moves. So far as construction arbitration is concerned, you can't overlook the fundamental fact that construction arbitration is something which involves some elements of technical subjects. Now, where does the arbitration start when you're talking of complex arbitration clause, complex infrastructure arbitration? Where does it start? It actually starts, as everybody has said, from the contracts. And everybody has talked about drafting of the clauses, the arbitration clause. But I go a step back. If you look at the entire contracting regime in most of the public procurement contract, because public procurement has been the biggest source of disputes, we have done so much of violence to the standard contract like FIDIC that we actually have forgotten really where the risk sits. And a large part of arbitrations arise out of this completely, unbalanced risk allocation under the construction contracts. And we, of course, when I started practice 40 years ago, we still had some standard CPWD and PWD contracts. We had standard, for example, things like claims of restricted turnover. How much is the profit and how much is the overhead? All these were codified, 10% and 15%. Now, today what we have landed up, we neither have FIDIC. Of course, if we are too immature as a construction industry to adopt NEC. So we don't have FIDIC, we have done violence to FIDIC, and we now want to sort out disputes amongst those contracts. And arbitration clause, as everybody knows, is the midnight clause, which is done the last thing and is least important when a contract for construction is being negotiated. The other part I would say, and which point has been touched by Anand in some ways, is when you're talking of infrastructure development, construction is necessarily a subset of infrastructure. And when you're talking of infrastructure development, you're talking of multiple contracts, which is related with concession agreements, financing agreements, and the construction contracts. Marrying all these together, and particularly, interpreting the contracts in the context of things like equivalent project relief is something which is so specialized that we have not created an ecosystem to really. Consolidation is one part of it. The second is how do we don't have an ecosystem within the arbitration community to deal with situations like this. And the fundamental reason is that we're not able to create that bandwidth from a technical perspective that is necessary. We are doing some steps. We have a large number of experts who have come and set shop in India, international experts. But then they are only confined to managing, giving evidences as experts. But we really need to create an ecosystem wherein we can really bring in the international best practices from a technical perspective. Of course, one reason is that, and I'll say with due respect to all the retired judges, we have not had a mixed tribunal. I think the ideal mix for a tribunal in a construction contract is if you have an engineer with you who can really, and I believe me, and in the Indian system, I would still trust the judges to come to the right conclusion, but they need that necessary assistance. I'll give you a very simple illustration. I was doing an arbitration many years ago. I had an engineer sitting next to me, and a very interesting question arose that the retired judge did not even know what a cantilever was. Now, this gentleman got so upset about it. He requested the tribunal to get up, took him outside his house, and he says, "You see this structure which is coming just above your window is a cantilever." So these are the things, and especially in terms of highly commercial, highly technical arbitrations like any oil industry, gas industry. These are highly specialized fields where we really need the assistance of experts, and experts not only as experts to depose in the tribunals, but experts in their own right as arbitrators. Therefore, I would only make these limited points, and because we are running short of time, undoubtedly we made very good strides towards handling these construction disputes, but we still have a long way to go. But had it not been for a very proactive retired judges community, probably we could have not reached here also, because the fact remains that the whole ecosystem of arbitrators is also getting sensitized to what we are talking today. And this sensitization has led to acceptability of a large number of changes that we have seen. And today, we have never heard of expert witnesses in India. Today, you have expert witnesses deposing not only as party witnesses, but also court appointed. And of course, the amendment to Section 26 has been a great help. And hopefully, this regime is going to move well forward. And at least I am personally very hopeful. It's a huge opportunity for all of us, not only the arbitrators, not only the councils, but also for the industry. Thank you.
Thank you, Mr. Sharma. In fact, taking a cue from what you said, I would request Mr. Sikri to add from his experience in the last 1 year of the challenges that he has faced. Also, any hacks that he discovered that the councils were innovative to reduce the stress from the tribunal, or use some innovative techniques while presenting their cases. While, sir, you answer that, I also wanted to bring about the question of Section 26 of the Arbitration and Conciliation Act, which provides for appointment of experts by the tribunal. And since you mentioned that there are some circumstances, some cases where parties do not take aid of experts, and ultimately such complex questions remain in the domain of the arbitral tribunal without getting any sort of assistance from the councils or experts. So why there is such a reluctance, at least in domestic fora, by arbitrators in appointing experts? Why don't we see that power being used as often as it should be?
Yeah, thank you, Shashank. Actually, Mr. Atul Sharma has virtually covered, both these aspects. But since you have asked me to share my experience in the last 1 year, he very rightly said that, look, it was, if I remember correctly, first 3 weeks and then 2 weeks thereafter of lockdown. So 5 to 6 weeks, or maybe 8 weeks, 2 months. And thereafter, as far as arbitration is concerned, all these hearings on virtual mode started. And thankfully, lawyers also cooperated. And till date, I have been doing only virtual hearings. I have not, except one matter last week. Now it was 1st to 2nd March, 1st and 2nd March, only one matter where because of confidentiality, I don't want to say what the case is about and who are the parties. But we thought, the arbitral tribunal thought that before proceeding, because it's a new arbitration, before proceeding further, let us have interaction with the two persons so that if it could be settled, we are more interested that they settle the matter. And except that virtual hearing, I have till date done all arbitrations on virtual mode, and in some cases, of course, hybrid hearing also, where the arbitral tribunal, all three members were, joined virtually, and the two parties, they agreed to be at a particular place and at a particular venue for the conduct of the proceedings. And it has gone very, very smoothly. And it has, I've seen great many advantages of that. In addition to what Mr. Atul Sharma has said, that number one, you are at home and you can join from here. I saw we have more time at our disposal now instead of traveling from one venue to the other for those cases, etc. And I think during this pandemic also have been able to deliver many awards. So even if I get, suppose I have two arbitration on a particular day and there's a in between gap of 1 hour, so that 1 hour also I'll utilize, I'll call my secretary and dictate him whatever urgent orders which are to be dictated or different mails, etc., which are to be answered. So those that time can be utilized, which was otherwise wasted. And same way, so that it is not only lawyers who are benefiting by sitting at home and doing court cases also and arbitration cases also, as Mr. Atul Sharma said, but we arbitrators are also benefited from that. You see, during this period, I think I must have, it's not only domestic arbitration, this international arbitration, some SIAC hearings, some 1 or 2 hearings under ICC, and one is this permanent court of arbitration. It is this investment, treaty dispute, and IBT. So therefore, we are able to have it on virtual mode, where the people are from different jurisdictions, and in IBT, there's the investment treaty case, where there are so many parties from so many countries, different jurisdictions, and 3 arbitrators also. I am from India, one from Australia, third from London, and we are able to have this, and it has gone up to now very smoothly. So what I'm trying to say is that, look, otherwise in any other case, you would have gone to either, suppose it was to in that case, like in normal course, it would be the seat is London. So we are going to London and having it there. So you are sitting here, you are able to do that case also, and one domestic arbitration also sitting here. And going to London means you would have spent time going, coming back, etc., for 1 day. But yeah, at the moment, these hearings which are taking place, they are mostly issues on consolidation of proceedings or bifurcation, etc. On these, particularly in international arbitrations, also we are able to do. I finished one SICC case, Singapore International Commercial Court. So I have that privilege that even after retirement, I am not only an arbitrator, because in that case, as like a judge, so we were examining one award passed. It's again SIAC matter where award, and naturally it had come under challenge. It's a partial award, but for 3 days we had that hearing, and it was hybrid hearing, as Kevin also mentioned about this. The judge from Singapore Supreme Court was sitting in the court, defendants were there in the court, the plaintiffs were in other country, and the 2 other international judges, me from India and one from Australia, Paris. So we had that hearing. So there are various advantages of this, there's no doubt. Of course, at the same time, physical hearings has its own advantages as well. But as you rightly mentioned, that the hybrid system may continue for some time, and particularly the minor aspects and CMCs, etc., in the beginning, which can be done in virtual mode, even when we go back to the normal periods, etc., should continue. As far as arbitration is concerned, it should continue even in court proceedings. I would go to that extent, and so that is one part. And coming to your Section 26 issue, which you have said, I have myself said so. Yeah, you are right. First, let me tell Mr. Atul Sharma mentioned about in construction contract. At least I think there are 4 or 5 cases, 2 cases which we have already heard, and in one case, I think no, both the cases we have given the award as well. and I was the presiding arbitrator in both the case. I had the privilege of having the technical person in construction case who was an engineer, because it is happening in other way. As you know, the two parties have to appoint, nominate their respective arbitrators, and the two arbitrators, co-arbitrators would nominate the chair. So many times I've seen, particularly in public sector, they nominate, there's some persons who is technical person. So it has happened in few cases. So therefore we were able to have it. Of course, you are right, and if both the parties, they choose some persons from legal fraternity only, either a lawyer or a judge, and the two judges also then choose presiding arbitrator, nominate a third also who is a judge. Then there's no, expert in that case. But as I have noticed in some of the cases, is that the parties are in India as well now, and the lawyers are also now conscious of this fact, that which are the issues where technical expertise is required. It can be at both places. It's not only technical in the sense that in construction, etc., engineering kind of technicalities, but particularly in construction contracts, when it comes to the quantum quantification of the claims, damages and compensation, etc. They need the expertise, again, expert, it may be a chartered accountant or any other expert. Suppose suppose it's a dispute about the valuation of shares. I'm just digressing from construction. So they again need expert. And I have seen that now in most of these cases, expert witnesses are brought before the arbitrators. And but you are right, at the end of the day, if it is not done, most of the time I found that in many cases that the arbitral tribunal has also not invoked 26 to have this, which should be whenever it finds some difficulty in tackling those technical issues. The now power is with the arbitral tribunal also to take that assistance, which should be resorted to more often. That is what I say.
Before I move on to the next question, if Mohan, Vijay, or Kevin, any of you would like to add from your experience of the last 1 year, quickly?
I just make two observations about the last 12 months. And when the pandemic hit, the first thing that happened to a number of the arbitrations that I was involved in was that it slowed everything down to the point where at least one ICC arbitration was suspended because parties were claiming that the pandemic and the lockdown meant that they couldn't even get checks to be physically signed, which is how they operated at that time. I mean, happily that has passed. But what has since then happened, I think, is that it's accelerated, ironically enough, what I think was already happening with many international arbitration, which is a growing reliance on technology, virtual hearings, electronic bundles. It was already taking place, but I think the pandemic has accelerated that. And what used to be an exception is now becoming the norm. And I think a lot of these changes are going to be fundamental because I think they have long-lasting impact on the way international arbitration is run. I don't think they will go away when the pandemic goes away. And I think it's a good thing with virtual hearings, because you save, as the judge has pointed out and Atul has mentioned as well, the flexibility and the savings in time translate to savings in costs. And that can only benefit parties because it means that things get done faster, it gets done more efficiently and at a lower cost. So I think there are permanent and lasting changes that have come out of this, which is going to be good for the world of international arbitration.
Thank you, Mohan. Also, I think what we're doing right now, a webinar like this, a masterclass like this was not possible before pandemic. Could be people thought about it, but the number of webinars, all of them being recorded, made available on YouTube and other platforms for people to look at it at their own convenience, is a remarkable addition to the scholarship. I think everybody has benefited greatly out of these experiences. Moving on, sorry, I thought somebody wanted to add something. Sorry. Moving on, I have a question for you, Mohan. Dispute boards, are there any practical options under FIDIC for a contractor that has a binding but not final DB decision that can pressure compliance by the employer?
I mean, we've looked at some of the complications that arises in an arbitration context. I think there are some answers, but those answers are not free from doubt. We've looked at the Passero case and some of the criticisms. I think there are some practical options that are open, and they arise because the FIDIC contract recognizes in clause 20.4 that a binding but not final decision by a dispute board has to be promptly given effect to, and that it is binding on the parties. I think the effect that a contractor is able to take from such a dispute board decision, if, for example, it involves payment of money, is to consider including that in an application for an interim payment certificate under FIDIC Red Book in clause 14.3, because 14.3, which is the provision that deals with application for interim payment certificate, recognizes that that certificate can include decisions that come under clause 20. Now, the question that you pose is practical. And I think there is a practical benefit that comes out of this, because if that certificate is then issued by the engineer and the employer maintains his stubborn attitude in not wanting to pay, FIDIC allows you the option of suspending the works under clause 16.1. So there is going to be some real and immediate effect on the works which a contractor can take, which is legitimate and which is contractually entitled to, which is going to provide some practical relief. It's not quite the same as being able to enforce it directly, but I think it provides an indirect and probably quite persuasive effect on the employer in the right circumstances.
Thank you, Mohan. A question, a follow-up on that for Vijayan. Vijayan, what are the key pre-arbitration aspects? We're talking about relevance of seat. What are some of the factors we should look out for when deciding on arbitration seats in our contracts? And this, I'm tying this with what Mohan has said. Would you also consider choice of arbitral institution given their expertise and the kind of panel that they maintain, who has knowledge of FIDIC contracts and has extensive experience in dealing with these kind of complex disputes? So your choice of seat and choice of institution, both.
Thanks, Shashank. Well, I mean, on the choice of institution, obviously I would say, the SIAC serves as a prime choice for a lot of construction parties, a lot of construction stakeholders. And that's because, not just because they're tied, in some part to Singapore as the seat, but it's also because of the way they've sort of managed arbitrations. And that's why I think, in terms of popularity amongst Indian parties, the SIAC is really head and shoulders above quite a number of other institutions out there. I think some of the relevant considerations when, we are deciding on which seat to select obviously turns on the reputation that the seats courts have. And I think Kevin very helpfully touched upon that quite a bit in quite a bit of detail. I mean, if it's Singapore seat, the Singapore courts will have curial jurisdiction. And that really affects the kind of powers that they may have in terms of pre-arbitral or even arbitral relief. I mean, some other considerations may turn on things like neutrality. If a lot of the parties are, say, Indian, Asian, and the other party is European, or even in the CIS region, Singapore more often than not serves as a neutral ground, which is detached from the politics of being in either of these kinds of regions. And maybe the last point to think about is the maturity of the seats arbitration ecosystem, if I use that word. And I think Mr. Sharma also mentioned that as well, because it turns on, is there a ready pool of sophisticated, experienced arbitrators there? Is it an environment which is out without disruption? And in the context of virtual hearings these days, does it have the kind of electronic infrastructure to support the kind of hearings with multinational parties? And so all these considerations, I think one needs to bear in mind when selecting the seat, and of course, when selecting the institution as well.
Thank you. Kevin, could you
Shashank,
answer?
I'm sorry, I'm interjecting. I have to leave, so I'm taking your permission to.
Thank you so much, sir.
Thank you, everybody.
Thank you, Justice.
Yes, we are talking of virtual world, but it is always nice to meet also one-to-one, and I hope we get that chance soon, and we'd like to have coffee with all of you at some point or the other.
Delighted to have you join us.
I hope the sequel of this is a physical conference sometime, sir.
Yeah. Thank you, everybody.
Thank you.
Bye.
Kevin, I was asking the same question to you with respect to choice of institution. Of course, from the point of view of SEAC, could you tell the audience what is the role of an institution while you select an arbitrator? How much of the merits of the dispute, complexity involved in the dispute, type of claims play a role when you appoint an arbitrator, and who makes that decision? I'm sure many of us know, but most of the in-house counsels may not have an idea how these arbitrators are selected.
Yeah, Shashank, we of course we've discussed this before, but I think that's ultimately why SIC is a good choice, because an institution is only as good as the arbitrator that the institution appoints, particularly in these kind of disputes. So we hope, because we take such pains to appoint the right arbitrator, that's why the construction disputes run very well at SIC. Basically, what happens is the Secretariat makes recommendations to the appointing authority. So the appointing authority, we have a president and two vice presidents. Lucy Reed, these are the appointing authorities, and we make recommendations. One thing that you have to be careful about from an institutional standpoint is how much you're going into the substantive merits as the Secretariat, particularly if an arbitrator has a very known position on a certain issue. So what you want to do is you want to look, of course, at the sector specialty, particularly in construction disputes. What has the institution's experience been with this arbitrator? Is this arbitrator able to marshal cases? Are there well-drafted awards? As I said before, I think that we have a really good insight into that because we review all of the awards. What is this arbitrator's experience with the seat, governing law? Obviously, we always appoint an arbitrator of a neutral nationality, but say in the appointment of a presiding arbitrator or a sole arbitrator, what are both sides going to think of this arbitrator? It's not just legal factors, but there's also soft factors. So if you had a dispute between a Malaysian party and an Indian party, a Singaporean arbitrator might make a lot of sense because of the connections between these jurisdictions, and both sides, particularly if that arbitrator is a specialist, probably feel confident in that arbitrator. The overall philosophy that we have as an institution is that we make lily white appointments. We want our appointments to absolutely be beyond reproach. And that also goes to the disclosure and the statement of independence that is signed by every arbitrator. I think one thing that's interesting in institutional arbitration is what institutions are doing with disclosures. This is particularly relevant following on Halliburton and Chubb. So is it the same for a party-nominated arbitrator, presiding arbitrator, sole arbitrator? So institutions really need to be careful about disclosures from the arbitrators, and how institutions handle that is also relevant. I guess appoint the right arbitrator. Arbitrations are very easy. That is why SIC is a meritocracy, because we are so busy and we have so many cases that we are always appointing the best in the world, wherever they are in the world, because that's how an arbitration runs smoothly.
There is a small query from one of the viewers about the technical arbitrators on your panel. So the viewers would like to know, do you often appoint technical people in complex disputes, and how good is your technical panel?
Yeah, that's one thing that we've been looking at developing is industry specialists. So I can think of quite a few arbitrators that are actually non-lawyers, but sector specialists. And this can be particularly valuable in a 3-member tribunal. As was mentioned earlier, that you want to have someone that is a technical expert. And we'll see this, and we'll often do this, particularly in the context of a multi-party appointment. So if the institution is charged with appointing all 3 arbitrators, you want to make sure that you have that sector specialty and the technical expertise. And sometimes parties are also going to want to have a commercial person, someone that understands the commercial realities of this dispute. And that's where the institution has to make a choice. What does this dispute look like? Are there commercial factors here that this arbitrator needs to be alive to? So we want to appoint a commercial person rather than, say, an academic that hasn't worked in the business and understands the practical realities of things. So we do have non-lawyers, industry specialists, but we are looking to develop more of that and get more of these kinds of people on our panel.
Thank you, Mr. Sharma. I have a question for you, which I would request Mr. Pillai also to supplement. Most of the times, the arbitrator does not understand the way how a project life cycle works, especially for mega projects. In such cases, what are the various criteria laid out in recent Arbitration Act in India? Now, I think to summarize this question, or rather to rephrase, what the viewer is trying to understand is when you have an arbitrator or possibly a former judge who may not have a technical expertise, he may not understand the life cycle of a mega project. So what is the best way to put it forward to simplify it in a complex dispute so that the arbitrator is able to understand the merits better? I understand this could be an India-centric question, but after you finish, I would ask the same to Mohan as well.
Yeah, Shashank, so far as the Indian regime is concerned, I don't think the Act can make any distinction between a construction arbitration or a commercial arbitration or a shareholder dispute. The Act can only give opportunities to bring that kind of material before the 26th Amendment has been so relevant. Now, if the arbitral tribunal is not understanding the technical aspects of it, you have the two opportunities. One is to bring in somebody as a party witness who is an expert, lead his evidence, and then let it be clear to the tribunal as to what are the technical issues at large. The second option is, of course, make an application to the tribunal for appointment of an expert for assisting the tribunal. So these are the two ways through which you can really make the tribunal understand what the technical aspects of the matter are. I have tried many a times. I was doing a cross-examination in a share valuation claim. I had the valuer sitting next to me. So in fact, I took a class from him. I was once doing an onshore drilling contract dispute. And of course, I didn't have, neither the tribunal nor most of the lawyers had the sense on how an oil well is drilled and how the geolographs, seismic studies are read. So in fact, I had to take about 3-day session from the experts, understand it, let the expert sit next to me as a client rep, and then take his assistance. So it's not that engineers are completely shut out to assist the lawyers. So they can still be used. So I think these are various ways through which you can really sensitize the tribunal about the technical aspects of the matter. And if they're not understanding, please read evidence by all means.
Before Mohan adds to it, can I request you to give your experience on any site visits requests? Has this been something that has been considered by the tribunals? Is it a better way to go about something as technical as, let's say, a steel plant or oil well, where tribunal could be requested to make a site visit and see how the plant is functioning? Is this something common in your experience from Indian perspective?
Shashank, I must say, until about 5 years, 10 years ago, this was quite common. But actually, this is a very thin edge on which you are walking. Because strictly speaking, the tribunal is not supposed to be the evidence gatherer. So therefore, there is a school of thought that if the tribunal goes and inspects a site and views and takes all those, that evidence into consideration, then probably they're acting as evidence gatherers, which they should not. And in fact, they could also be, in that case, subject to cross-examination. So that's something which is very difficult to answer. But I for one, believe that the evidence is to be led by the parties. If they want to do it through a presentation, if they want to through walkthroughs or whatever they want to do, it is not for judges to go and look at the sites. And I'm sure Mohan can probably, in his experience, come out with a situation like this, At least I personally believe that that's not job. That's not the job of a tribunal, and they should stay shy of that step because they are always tempted. I was doing an arbitration just recently, which Anand mentioned. On the road, the diversion of traffic from a road, and this was an arbitration where our case was that our traffic is reduced to half. And of course, the other side, they was very keen that the tribunal should condition of those roads and come to a conclusion, which I resisted, and of course my reasoning prevailed. I was lucky enough, but then I have that view, right or wrong. I think probably Mohan can comment on that.
All right. I'm just reminded of the old adage that a good lawyer knows the law, an outstanding lawyer knows the judge, and that comment is aimed at understanding the individual or the group of individuals that are going to be sitting in judgment of your case, and if the individual because he recognizes or she recognizes that you've got a problem where there may be a gap in the knowledge of the person who is going to be looking at this that might end up with an inaccurate assessment because of that lack of the knowledge about the project cycle. And then there are two ways, in my view, to try and deal with that. The first is be careful and be very conscious of what you need when you're appointing your tribunal. Unlike a judge whom you have no choice as to who you get assigned to your case, you have a level of control in arbitration tribunals. And I know it is very, very common. In fact, I've not yet come across an Indian arbitration which did not have a 3-member tribunal. So everybody's got a chance to appoint a tribunal member, and that is a choice that should be made carefully with a great deal of thought to identify the right individual. But you still only have the ability to have 1 out of 3. The way in which I think then to try and deal with this potential gap that you might have is to ensure that between your factual witness and your expert witness, you paint a story effectively that deals with this information gap that you perceive might exist. And these days with technology, you can do, as I have seen in many cases, computer animation, which explains in a progressive way what has been involved in this particular project with animation, with graphics, and with computer programs, which gets a tribunal on board so very, very quickly compared to reading 35 pages of a report that tries to explain what it takes 2 minutes to see. So some of this technology is really available. And certainly in cases where we've had to deal with complex project cycles, we have sat down with our expert and our factual witness to try and explore what is the most effective way of trying to convey what is a complicated, difficult exercise. This tends to happen quite a lot with industrial plants. And the alternative to writing out a report that explains all of this is to present something visually. And I find that much more effective if it is done properly and if it is done well. It takes a bit of time and investment and money, but in many cases, it is well worth the time and the additional cost that it generates.
Thank you. It's very insightful. I would you from you talk about the FedEx subcontract topic one, how it provides for a framework where the subcontractor's dispute is suspended for about 100 odd days. Have you had this subcontract form used on a matter before, and what were the difficulties that you faced?
Thanks, Shashank. I mean, we do have a current matter now which involves this particular subcontract framework. I mean, I won't delve too much into the specifics given, confidentiality considerations, but I think some of the common issues that will arise is perhaps one, whether the subcontractor even accepts that its dispute with the main contractor involves disputes up the line with the employer. And what happens if it does dispute that notification by the main contractor? A second potential issue that may arise could be, what if the main contract dispute proceedings takes longer than 84 days, and therefore it eats into the 100 odd days where the subcontract dispute proceedings is suspended. Now, how is that going to pan out? Is that acceptable to parties? What objections could be taken? It could be a second issue. I mean, the third could very well be whether or not the subcontractor wishes to assist the main contractor in preparing its claim for its upstream submission to the employer. To what extent of this assistance is required? Can the subcontractor say no? And there are complications that arise out of that as well. So it is fraught with difficulty, and that is common, I think, for all contracts. I mean, in particular, the subcontract, given that this is quite a new phenomenon that's being tried out by FIDIC.
Thank you. Mr. Sharma, there is a question on the acceptability of emergency arbitral awards in India, given the backdrop of the latest judgment that we have seen of Delhi High Court and Amazon future dispute. In fact, Padmaja has also sent a question. She says, with emergency arbitrators awards being recognized as enforceable in India, do you perceive that there will be an impact in the continued use of Section 9 as a remedy for urgent interim relief in institutional arbitration cases? Is it time for the courts to encourage parties to seek emergency arbitration instead of domestic recourse? And I'll just add one more line to this. Do we have this as a parallel remedy available, or a party has to elect? Can a party, after losing in a Section 9, go before an emergency arbitrator, or the other way around? Can a party not getting the relief before the emergency arbitrator go in Section 9 for an Indian court?
Oh, I mean, let's understand. See, these are two buckets in which you need to keep, and the bucket, of course, if you look historically, Section 9 has been brought in only because, if you remember the judgments which were relating to Section 11, and then came the question as to whether when does the role of the tribunal comes in. So, so there are two buckets. One was pre-constitutional tribunal, and the second was post-constitution. And now, of course, after the amendment, it will obviously, there are limitations in terms of how long that relief granted in Section 9 will be valid. So therefore, in my perception, emergency arbitration, so far as Indian statute is concerned, is a non-starter. So far as Singapore is concerned, it has a regime which is statutorily recognized, and SIAC, of course, has created that ecosystem wherein those emergency arbitrations can be invoked and emergency orders can be obtained. I don't know, it's difficult to say as to what is the conflict between this domestic, but I suspect that once you have failed in Section 9 or vice versa, if you have failed to achieve any interim relief under the emergency arbitration in Singapore, you can come to India and claim the same relief. I believe that principles of forum shopping could have a role to play. Although, strictly speaking, Indian court will not have the jurisdiction. I mean, it depends on what the seat is. But of course, there will be no jurisdiction because at the end of the day, jurisdiction in this case is the territorial matter. So you cannot strictly say that because you have gone to Singapore or you have gone to India in Section 9, I don't know how Singapore courts will react or the tribunals will react, but Indian courts will take into account the principle of forum shopping if it's the other way around. If you've gone to Singapore or you've not got the relief, now you're filing the same application in India in Section 9. So it's a gray area, and I must admit that, but the fact remains that in India, so far as domestic awards arbitrations are concerned, as of now, and I believe that emergency arbitrations will be a non-starter and Section 9 will continue to hold the field. Because the way this whole provision is structured, it's not going to take off.
Right. I think we're running short of time, so I will take one last question. This is for you, Mohan. With respect to case management, does the partial procedural timetable approach offer real advantages over having a full procedural timetable right at the start of the proceedings?
I don't think it's particularly clear. I say that because the model that I was examining in the course of my presentation, which is in the ICC 2019 report, refers to a partial timetable that takes the parties all the way through the conclusion of the factual and expert evidence already being presented. So, you've got a fairly limited amount of work after that. I mean, what are you looking at? You're probably looking at things like the submission of the agreed bundle. You are probably taking a look at how witness evidence is going to be managed in terms of whether you're going to be having witness conferencing, when opening statements are going to be filed, things of that sort. And most tribunals will, in any event, have a case management conference near but not too far close to the hearing, where they will be discussing these matters anyway. So I think that the advantage is going to be limited. I think if you take a look at, on a balance, having a full procedural timetable gives a level of confidence, gives a level of clarity, gives a level of predictability, so that parties will, over the next 12 to 15 months, have various targets that they can plan and start scheduling. And I think leaving it sort of hanging in the air when 80% of the timetable is already set, and just leaving that last 15 or 20% hanging in the air is really unhelpful. What I think is more helpful is if you're looking at a partial timetable, the case has got to be on the basis that there is a complete lack of clarity at the very early stage of the arbitration as to what the case is going to be. The respondent says that there is a lack of detail that is being made available, and therefore it would be unhelpful for the tribunal to start formulating a level of detail. I mean, in a situation like that, you can have a circumstance where the tribunal might say, fine, we will make directions for the pleadings to be filed, and then the parties come back when pleadings are close to have a discussion with the tribunal in about 2 months' time as to what the pleadings disclose, the gravity of the dispute between the parties, so that we can then at that stage consider what we're going to do. I think that makes more sense than having a timetable that takes you so far down the road that it makes very little sense to leave what little there is unregulated. You might as well deal with everything at one go. And if you want to have a partial timetable, then stop quite early in the day when there is a justifiable lack of information about the nature of the case.
I wonder how do arbitrators give disclosure right before they even know what the dispute is likely to be and the complexities involved. I think going forward, at least as far as Indian Arbitration Act is concerned, we should amend the format of disclosure to have a continuous disclosure. There should be a disclosure after the procedural timetable has been laid out for the arbitrators to reflect if they will be able to finish this within next 12 months. Because it would ultimately be a deciding factor for a lot of parties and even for institutions, that whether this arbitrators diary has that sort of time.
I think you're right. I'm sure Kevin will be able to add to this, but my experience with SIAC, when appointments are being considered, is that's one of the questions they will ask you. What is your availability? What are your commitments over the next 12 to 18 months? And, that is part of the disclosure that an arbitrator that is being considered is expected to make, because as someone like SIAC would want the comfort of knowing that you don't have 5 arbitrations already running that is going to occupy you for the next 12 to 18 months, so that this 6th arbitration is going to be right at the end of the pack. So I think, that's one of the things that they would ask for. And you're right, Shashank, at the point when the arbitrator is taking the appointment, he won't have enough details. But I think he needs to have the foresight to understand that he's being entrusted to deal with an arbitration. And if he doesn't have the flexibility to be able to accommodate an arbitration, which he will need some time to come to grips with, then he really needs to think twice about whether he should be stepping forward to be considered for appointment.
Yeah. Kevin, you wish to add something to that?
I would second all of that. And I think that that's a very good development for arbitration. And it ties in a bit to what Mohan was saying about the amount of time after the close of proceedings. I can remember about 10 years ago, there used to be this idea that certain arbitrators would take a year to draft an award, and that everyone kind of accepted it. And I can remember having a counsel that called me and said, but I know who he is, but it's not fair. My client is getting really upset. This is a bet the company dispute for us. And there's no tolerance for it anymore. Arbitrators need to be really careful about the amount of cases that they take on. And they need to know that they have the availability. And we've seen very good things of arbitrators saying, I would love to take this case, but I just don't have the time. because I've seen arbitrators get in trouble because they take too many cases if they're also counsel, double hatting. And as Mohan said, if your case ends up being the one that's at the end of the line, that's not very good for the parties and it's not good for SIC. So we have no tolerance for arbitrators who are perpetually delayed, and it's also going to affect the arbitrator's fees. We will tax an arbitrator's fees if they've not been able to handle a case expeditiously and efficiently, and more importantly, we probably won't appoint them again.
Thank you very much. I think we're running short of time, so we would have to conclude this very stimulating and interesting panel discussion. And as promised before, and we have lived to that promise, there will be a sequel of this event, and there will be other topics that will be discussed. There will be further queries that will be taken up when the sequel is organized. We'll move on to the last part of the event, which is a short closing that I am supposed to give. So I'll begin with thanking everyone who has joined us today for this very, very interesting and intriguing masterclass. Our statistics show that we had over 250 registrations today from experienced industry professionals, arbitrators, lawyers from more than 11 countries. Come to think of it, such diversity, where we have speakers, attendees, and from so many different jurisdictions, is rather a rare occurrence pre-COVID. However, the silver lining of this pandemic has seen the legal fraternity come across the globe to come together to share their cross-jurisdictional expertise for the benefit of lawyers at large. And today's masterclass is one such example. Our speakers throughout the day have shared their perspectives from different walks: the Indian perspective, the international perspective, the tribunal's perspective, the arbitral institution's perspective. Mr. Hassan and Mr. Srivastava in the morning panel shared their experience pertaining to pre-arbitration aspects in domestic arbitrations, strategies for effective management of the process involving tips on drafting of pleadings, submission and expert witness, and enforcement of awards. In the afternoon, we had Mohan and Mian who shared their international perspective on the relevance of seat, constitution of tribunal, jurisdiction, interim relief, emergency arbitrator, case management tips, practical experience during the merit hearings. Then we had the privilege of having Justice Sikri and Kevin, who shared some very, very relevant examples from their perspective of an arbitral tribunal and of an arbitral institution in the case of Kevin. And Kevin's vast experience with SIAC, as Vijayan has already pointed out, SIAC is amongst one of the leading institutes when it comes to construction arbitration and effective management of such cases. From the discussions that took place today, it is clear that the stakeholders must be mindful of certain aspects at every stage of arbitral process in order to effectively manage a construction arbitration. Some examples would be composition of the tribunal, including selection of tribunal, terms of reference, case management conferences. I think Justice Sikri and Mohan both emphasized about these points. Procedures, agreed procedures, and the procedures that have been decided by the tribunal. Quantification of claims by experts. Site visits. We just had a short discussion, Mr. Pillai and Mr. Sharma. A site visit would be equally important for counsels, if not for the tribunal. Sometimes, of course, experts and clients may come to your office and explain how a steel plant or a blast furnace functions, but sometimes it is equally important to visit and understand the nuances involved in such complex disputes. Witnesses, merit hearings, all these aspects we have covered throughout the 3 technical sessions that we had. This masterclass would not have been possible without our eminent speakers who took out time from their very busy and hectic schedule. I must thank Honorable Justice Sikri, Mr. Nusrat Hassan, Mr. Anand Srivastava, Mr. Mohan Pillai, Mr. Vijayan, Mr. Kevin Nash, Mr. Atul Sharma, our speakers for the day, who used their incredible experience and hand over several tips from live examples of some of the cases that they have encountered in the last 12 months and many before that. I must also thank Ms. Padmaja Paul, my co-chair for today, Mr. Shobit Mohan, Assistant Professor of Maharashtra University, for being instrumental in marshalling today's event. It takes a lot of effort, planning, and execution to organize something, especially over a virtual platform where there is absolutely no room for error. I must thank the Society of Construction Law Young Leaders Group, Center of Excellence in Alternative Dispute Resolution, Maharashtra University, Link Legal, Suveeksha, SIAC, Bar and Bench for this continuous support for today's masterclass. And finally, I must thank all the attendees who took time to stay throughout the day and became an active part of today's event through their questions and interaction. This entire recording would be available online, and all the attendees will be sent an email follow-up with the recording link in it. So those who missed any part of the workshop today can take the advantage of that recording, which will be available shortly. Thank you. Have a great weekend.
Thank you. Bye, everyone. Have a good weekend.
Thank you, Shashank. Bye, everybody. Have a lovely
Bye.